were present earlier when the court explained the nature of an informal hearing. True?
Yes.
Thank you. So you understood the court's instruction that you must select from one of three options to protect your rights, yes?
Yes.
Thank you. Ms. Schitt, the citation before the court was issued May 23rd this year at 13 past 11 in the evening. You were operating a Chevrolet Trax, white in color, on 3rd Street, Adrian, Maine, in the city of Royal Oak. At that place and time, you were cited for impeding traffic, which is a 0-point non-abstractable or non-recordable civil infraction. As well, you were cited for expired plates. It appears as though the plate had expired in March of 26, and you were unable to produce a physical proof of insurance at the officer's request. So all three of these matters are 0 points. 2 of them are documentary. As to these, the court would simply make note of the fact that Officer Hull appears to have written an impeding traffic ticket, but what he suggests he witnessed was a disobey red signal. Regardless of that, Ms. Schitt, today is your day in court. You may admit responsibility. You can admit, explain, and display some updated paperwork, or you can deny responsibility and the court will commence your trial forthwith. What do you wish the court to do?
I'll accept the responsibility.
Very well. So you're confirming to the court that on the date in question, you were operating a motor vehicle in the city of Royal Oak. In some form or fashion, you impeded traffic, and at that particular point, you were unable to produce a valid current proof of insurance, and the vehicle tag had expired in March, correct?
Yep.
Thank you. The court accepts your plea. What would you like the court to know?
I went to the court. I showed them my proof of insurance, and I showed them my new registration, because my car is under my dad's name, and he's been overseas, and it was his birthday March, and he wasn't here. And I got a new plate, and I got a new insurance under my brother's name now.
Okay. Officer Hull, the court is looking at a Farm Bureau insurance certificate, but in particular, this one suggests it expired on June 5th.
Yeah, that they gave us only for a week, and they mailed us the they mailed us for the 6 month.
Okay. Do you happen to have that proof of insurance with you right now?
I don't have it with me, but I can show to the court, or I can drive there when I pay my fine.
Thank you. And the court will check on that registration.
Sure.
The registration is updated till the end of November.
Yep, that's a new number and new.
This is on the Chevy Trax.
Yep.
Okay. Thank you very much for all of that. Ms. Schitt, Officer Hull, what would you like to share?
I'd like to make a motion to dismiss the expired plates and proof of insurance.
Very well. So, Ms. Schitt, those two will be dismissed.
Thank you.
And with respect to the impeding traffic, the fine for that is $175. That is payable through the pay portal on the court's website, or you can walk a cash check or charge into this court at 400 East 11 Mile Road, Monday through Friday between 8:30 and 4:30. That's due within 14 days. That completes your hearing. Good luck to you.
Okay.
School will be coming back in session in the next 30 days or so. So.
Okay. Thank you so much. Have a good day.
Bye-bye.
Bye.
All right, let's try this once again, everybody. Good morning. Welcome to TCF Live. Happy Wednesday to you. My name is Dan, guiding you on a 3-hour journey through Courtlandia. Also, earlier when you could not hear me, I said happy birthday, Lindsay, and happy anniversary to Nancy. We'll continue with the magistrate.
Calling case number 26, RO 03098 and 98A. These are people versus Nathan Frederick Garner. That's you, sir?
Yes, Your Honor.
Thank you very much. Mr. Garner, you were present earlier when the court explained the nature of an informal hearing. True?
True.
So you understood the court's instruction that you must select from one of three options to protect your rights, yes?
Yes, Your Honor.
Thank you, Mr. Garner. The citation before the court was issued May 9 this year at 10 minutes of 9. In the evening, you were operating a 2008 Suzuki motorcycle, GSX-R 750, black in color, on 12 Mile Road and near Main Street. At that place and time, you were cited for exceeding the posted speed limit by a minimum of 1 to a maximum of 5 miles over. And you were also cited for changing lanes without due care and caution. Officer Hall's remark, which shows on your ticket, indicates operator of radar, which was Officer Hall, had a margin of speed of 50 and a 35. And he noted a motorcycle splitting lanes and making multiple lane changes without a turn signal. So those are two citations that are before the court at this moment, but those are simply allegations at this point. Mr. Garner, you can admit responsibility in these matters. You may admit and explain, or you can deny responsibility, and the court will swear the parties and commence your trial. What do you want the court to do for you?
Responsibility with explanation.
Very well. So you're confirming to the court that on the date in question, you were operating a motor vehicle, to wit, a Suzuki motorcycle, in the city of Royal Oak. You exceeded the posted speed by at least 1 mile, and you were changing lanes without due care and caution, correct?
Yes, Your Honor.
Thank you. The court is grateful for your honesty. What's going on, Mr. Garner?
I don't think I was going 50, but I was so I was splitting like two cars after coming to or rather after a red light.
Okay. But obviously you've just offered a admission to speeding at least 1 mile over the speed limit, correct?
Yes, Your Honor.
Okay. The thing about how old are you today?
I'm 19, Your Honor.
All right. You'll be driving for another 60 or more years. The court is always glad when it has a motorcyclist in front of it, especially a young motorcyclist, that we're not having the same conversation in an emergency room or a funeral home, because there's just no protection between you and that road. You might as well be riding a gum wrapper, okay? And not everybody pays close attention. And if a motorcycle's in a blind spot and a person just decides to change a lane, or they spill hot coffee, or they look down at your phone, your parents could have had a really bad day, okay? So please be careful out there, but the court is grateful for your honesty. Officer Hall, anything you want to share regarding Mr. Garner?
No, Magistrate.
Thank you. Mr. Garner, 1 to 5 is a $130 fine that is payable through the pay portal on the 44th District Court website. And due care and caution is also 130. The court's going to reduce that fine to 100 even. So your grand total today is 230, again, payable through the pay portal on the 44th District Court website, or you can walk a cash check or charge into this court, 400 East 11 Mile Road, Monday through Friday between 8:30 and 4:30. That's due within 14 days. Please be careful out there.
Thank
Good luck
you, Your
to you.
Honor.
I'll check on that one. Brother Gothard, I do see you.
Take up space, I apologize.
Calling case number 26 RO 03687. This is people of the city of Royal Oak versus Ryan James Christie. Is that
Yes.
you?
Christie.
Christie. Mr. Christie, you were present earlier when the court explained the nature of an informal hearing. True?
Yes, correct.
So you understood the court's instruction that you must select from one of three options to protect your rights, yes?
Yes.
Mr. Christie, the citation before the court was issued May 28th this year at 8:03 in the evening. You were operating a 2026 BMW 330XI, silver in color, on Crooks Road at or near Webster in the city of Royal Oak at that place and time. You were cited for exceeding the posted speed by a minimum of 1 to a maximum of 5 miles over. The posted speed at that vicinity is 30 miles per hour. Officer Hall notes a margin of speed of 47 and a 30, but he chose to write this for the significantly more modest level of 1 to 5 over. Regardless, Mr. Christie, today is your day in court. You may admit responsibility. You may admit and explain, or you can deny responsibility, and the court will swear the parties and conduct your trial. What do you wish the court to do for you?
I would like to admit responsibility and thank Officer Hall for making that reduction already.
Okay.
But
We have to we have to make sure the record's clear before we move any further with an explanation. So you are confirming that on the date in question, you were operating a motor vehicle in the city of Royal Oak and exceeded the posted speed by at least 1 mile over, correct?
Yes.
Thank you. Okay. Now you were thanking Officer Hall there a minute ago. What else would you like the court to know?
I'd like to thank Officer Hall for his leniency, but I would like to see if there's any other way to get this reduced to a non-moving violation or something or other. I care about my driving record and my insurance rate, whether that be additional fines or traffic school. I would like to see if there are any other options.
Okay. The court appreciates your request. The court doesn't have the authority to grant it. The court can't add or subtract points. The court's simply the umpire here, but certainly you haven't been driving for too terribly long. Court has no idea what your driving record looks like, but would defer to Officer Hall for any additional input.
Yes, Magistrate. I'll make a motion to amend this to impeding traffic.
Very well. A motion to amend impeding traffic, Mr. Christie, which would get you where you want to be.
Thank you,
A
Officer.
0-point violation doesn't permanently appear on a master driving record. Your fine today, therefore, is $175, payable through the pay portal on the 44th District Court website, or you can walk a cab, check, or charge into this court at 400 East 11 Mile Road, Monday through Friday between 8:30 and 4:30. That is due within 14 days. Please be careful out there.
All right. Thank you.
Good luck to you.
Thank you.
Well, good for him. He was nice to the officer and got out of having some points on his license. That's always cool. Correction to what I said in the chat, because I believe in being accurate here. Julie and I were having a convo back and forth about lane splitting here in Arizona, and she said she thought it was filtering. She is correct. I stand corrected, but unfortunately I don't think the majority of people who ride motorcycles here in Arizona get it either. Officially, Arizona made lane filtering legal, where the traffic is stopped, the road has to have a posted speed of 45 or less, there has to be 2 or more adjacent lanes, and then a motorcycle can basically split the lanes to move up to the front of the line to get up to like the front of the red light. That is unfortunately not how I see it practiced out here in Arizona, where they're just blowing right by you as you're driving, splitting lanes while moving. So, but that is officially what it is. So thank you, Julie, for helping get me corrected on that. Let's stay in Michigan. Let's go to Judge McNally.
B. Ma'am, you can go right. John, why don't you set that, get those files off of there. Somebody ever sit there. You can have a seat right there, okay? Or you can argue with the podium if you want to. Either way is fine.
Okay, I'll stand right here.
Okay,
I did have a copy of that motion for you.
I've read them. Your name
Shannon Phillips.
and your name?
Caitlin Fully Carter in Jasmine Township.
Okay, you can go ahead and proceed with your motion, Ms. Phillips.
So, good morning, Your Honor. Shannon Phillips on my own behalf. I am here on the motion to dismiss.
And you still don't want a lawyer?
No, sir.
Okay, because you know I'll give you one, right? I just want to cover that.
Yeah,
with you.
that's my right.
Okay.
And it's also my right to represent
You
myself.
can represent yourself. I don't have a problem with that. Go ahead.
Okay, I am here on my motion to dismiss both counts of hinder and obstruct a public servant. I am asking the court to dismiss these charges with prejudice because the officer's own body camera proves he was biased. His commands
Do
were.
you have the body cam?
Yes, sir. I did bring the USB with Officer McParland's body camera.
Have you seen that, Ms. Foley Carter?
Very different interpretations of the body cam.
Okay, well, I would like to see the body cam footage, so Heather, can I send her down there and you guys can get her set up where we can put it on the screen?
I don't think we can do it through here. I think it has to be set up through there. Let me check with Shane.
Okay,
Yeah,
She has it on USB, is that what she said? Am I
how
correct?
lengthy is it?
It's 25 minutes. I didn't want to edit it or make any edits, but it is 25 minutes about.
Jeez.
I did create timestamps of the necessary, him telling me to get out and then trapping me, not letting me leave, never telling me I was under arrest, him apologizing to the sergeant, saying,
Thank you.
I had to go hands on her. I'm sorry, Sarge, I had to do that. She's claiming I pushed through the officer. My hands were up the whole time. And yes, I walked to the door.
Okay, so let me ask you a question.
Yes,
Well, why isn't this a fact question? Why isn't this for the jury to decide, or me if there's a bench trial?
we can go to trial. We can go to trial. You don't have to dismiss, we can go straight to trial. I'm okay with that and I'm ready to move forward.
Okay. So you're gonna withdraw your motion to dismiss? Is that what you're gonna do?
I mean, if you don't want to watch the video and you dismiss the charges after watching the video, then we can go to trial, sir. Hey, I don't want to argue. I don't want to fight.
No one, hang on. I'm not arguing with you. You take me as arguing with you?
No, I'm just saying, sir. I don't, the back and forth, like, I don't want to do it. But again, we can go to
What do
trial.
you mean, what back and forth? Tell me, I don't wanna know what you're saying.
What you're saying, you don't want to take this to trial and whatnot.
I did not say that.
We
Where
can't.
did I say that?
What
I
you
said, why isn't this a fact question? She's looked at the video. She disagrees with you. She's duty bound to dismiss the case if there's no valid charge here. It's based on what's in a body cam. And, I'm just asking you, I'm not treating you any different than I would a lawyer. If a lawyer filed this motion, I'd be asking him or her the same questions. Why isn't this a fact question?
I know, Your Honor. Could you rephrase the question what you're trying to ask?
What-
I feel like it should be dismissed. Because I was never told I was under arrest. They assaulted me and then tried to cover it up. This happened April 29th. She only filed charges on 5/13. I also have another pending charge that she wrote in her response. Trying to make it seem like I'm just some criminal. Saying, oh, she has prior stalking charges that we're currently going to trial for now. But those same charges, she wants me to plead to a disorderly person.
Well, you don't have to plead to anything.
Exactly, we're going to try it. So, like I said, I brought the USB if you would like to watch it and whatnot. And yeah, if not, we can go to trial. I believe she won't be able to prove all the elements beyond a reasonable doubt.
And then, so after she puts her proofs on, and after you cross-examine her witnesses, if it's a jury trial, you can make a motion for a directed verdict.
Yes,
And then I have to take all the evidence, just so you know, in a light most favorable to them, and find that a reasonable fact finder could not find that proof exists beyond a reasonable doubt. That's all I'm trying to tell you nicely here. It's not that I don't want to look at the video. I'd be hard pressed to stop everybody else's court proceeding today so I can take a look at a video that's 25 minutes. Can you figure out a way to copy that?
Yeah, you don't want to play it now, you just want.
Yeah, because I don't know how I can make everybody wait for 25 minutes.
Your Honor, I can send it to the court. So you don't need to make a copy of it.
Okay.
I mean, or you can have this USB. I made it so before the court.
Well, I don't want to take your evidence from you here and be responsible for it. Here's what I'm going to do. This was an arraignment June 17th. This is July the 29th. Here's what I'm going to do. I'm going to set this for a jury trial, and I'm going to set it for a final pretrial. So we're going to set a jury trial date right now. And then we're going to set a final pretrial date, motion hearing date, the same. We'll do it at the same time. And I'll review the video before you come back for a body cam video before you come back, okay?
Okay, and then just so you know, I have trial with Heston August 6th and 7th.
Judge us.
Mhm.
Yes, that's fine. Give me a jury trial date if you would, Heather.
I'm sorry, when did she say she had the jury trial with Judge Hassan?
She said August 6th and 7th. We're not setting.
Oh,
this
okay,
date.
that's good, okay. Let me look at our calendar, make sure you don't have anything on this. We have
Maybe we should.
August 21st available, we have August 28th, I believe,
Set
available.
this, wait a minute, let's do this. Let's pick the final pretrial date first. Because I'm not
Okay.
gonna be here in 2 weeks, right? So,
Correct, so we could do okay, so our final pretrial, we would have to do on the 20th.
August the 20th.
Yes,
And let's do this later in the morning at 11 a.m.
okay,
And you send that to me, Ms. Foley Carter, CC her on your email, whoever you're sending it to. I'll review it. Somebody, you need to give me that the day before, 2 days before, Sadie, okay? Can you make a note of that? And then, we'll set a jury trial date right now. When can I do that?
let's see, you have one September 11th already. Do you want to do September 18th?
Who's September 11th?
Wendy Augustinus.
It's with me, Your Honor.
What's that kind of case?
It's a disorderly person.
Is that likely to go?
I will know today.
We're gonna set this for September the 11th right now at 8:30 in the morning. Proposed jury instructions, Ms. Phillip. Now listen to me very carefully. You think you two can get along and prepare joint jury instructions? Are you gonna be cooperative with her, Ms. Phillips?
Yeah, that's fine. I'm always cooperative.
I'm not suggesting you're not. You're fine. Just you don't need to come in with an attitude. I'm gonna hear you. And if you deserve to win, you're gonna win this case. Okay? If you don't, you're not. Period, plain simple. But I didn't ask you to comment as to whether or not you're cooperative. I'm asking, I know there's some bad blood here. I can tell by the briefs, and I can tell how you've come in here before, in fairness. And I just want to make sure that you think you can get I can either have you do separate proposed jury instructions, or you guys can get together and submit a jury instructions that you both agree to, with the understanding, if you don't agree on an instruction, then I'll hear arguments on that in that regard, and I'll decide whether or not the instruction should be read. Can you get with Ms. Foley Carter?
I'm sure we can, Ron.
Okay.
We've been talking really well through email, so I.
Okay, good. All right. Now, listen to me very carefully. I mean, no disrespect with this. What is your highest level of education?
Some college.
These people, they go to law school. They pass the bar exam. Then they work at practicing for years. Like You wouldn't expect if I got hurt that I would hire you to be my doctor, or if I needed a tooth pulled that I'd hire you to be my dentist. I'm only telling you, you can think about it. You have every right to defend yourself. But but just understand that you are subject to having knowledge of the rules of evidence, the rules that apply in a jury trial. I personally have only seen 1 or 2 people do that very well in my 31 and a half years here that are lay people. Maybe you'll be the best. I don't know. I'm just suggesting to you that you reconsider what I'm telling you and that you consider allowing me to appoint you a lawyer. You don't want a lawyer. You can run these gamuts all you want. You know, you can run the whole gamut if you want. And I'm just telling you, the last thing I want to see happen is somebody get convicted that didn't do anything wrong. And that's always subject to a real possibility when they're doing something that they probably aren't equipped to do. You're not equipped to be a lawyer. You have the right. You have the right. Do you understand what I'm saying?
Yes, I understand, Your Honor. I went through the same thing with Hesson.
Judge Hesson.
Charge.
Judge Hesson.
And yeah, I understand she is has a lot of experience. But Your Honor, I'll be okay.
All right. So we're going to put this down for proposed jury instructions due by, I'm going to say, September the 2nd. We're going to have the motion hearing on August 20th at 11. And the jury trial September 11 at 8:30. Okay. And that's it. Is there anything anybody else would like to bring up?
No.
Ms. Foley Carter? Anything? Okay. All right. Good luck. Go down the hall. We'll give you your notice, man. Thank you.
Thank you.
Thank you.
I'll see that file.
We'll need a rubber band. And then here's my.
So thank you, Austin, for making a note on that. I'm sure we'll see her again because we know when to look for her now. So thank you, Austin. We are awaiting the arrival of Horderman at some point here in Judge McNally's court, so we'll keep an eye there. Let's go say good morning to Judge Anzalone, see what's going on with her.
This is Mr. Pearson.
Yes, Your Honor.
These are files number 2026-22697FC and 2026-22698FH in the matter of the people of the state of Michigan versus Andre, is it pronounced Deshaun? Okay, Pearson. I have Matt Murphy appearing on behalf of Mr. Pearson, and I have Isaac Sneed appearing on behalf of the people. This is the date and time set for arraignment on both of these files. Mr. Murphy, do you waive the reading of the felony information?
Yes, Your Honor. We acknowledge receipt of said information, the witness list, and the discovery request by the prosecution in this matter. At this point, we would waive a reading of the information on the record. We'd ask the court to just set a pretrial in this matter for whatever fit the court's schedule best. And that's all.
All right. Do you want August or September?
Your Honor, could we do September? There's still some discussions. I'm not quite sure if we'll have it resolved.
September 2nd or September 9?
Can we do September 9, please, Your Honor?
All right. So I will set these over to September 9 at 8:30 in the morning because it's an arraignment. My staff will prepare the notice of hearing. So Mr. Pearson is here in person today. Does he need to be in person for the next one or via Zoom?
We're actually be in person, Your Honor. He had a really, really difficult time understanding what was occurring over Zoom when he was appearing.
That's fine. All right, so Mr. Pearson, we'll bring you back in person, okay? Thank you.
Thank you, Your Honor.
Short and sweet hearing from Judge Anzalone. Let's go to Lake County, Ohio. Judge O'Donnell, let's see who he's swearing out this morning.
How does he wish to proceed today?
Judge, he admits to have violated the terms and conditions of his probation.
Is that what you want to do?
Yes, Your Honor.
What's your plea to the violation?
Guilty.
Guilty, Your Honor.
All right, I'll accept your guilty plea and find you guilty. So, as I understand it, the I don't want to say the cause, but a strong contributing factor to this was your alcohol intake that day. What was that all about?
I was just depressed that day, and I made a very bad decision, Your Honor.
What was going on that you were depressed such that you...
All this, just sad that I haven't had a license in a long time, a lot of stress at work, depressed that I'm in trouble, just general stuff like that. Not a good thinking mentality.
All right, so how's that going to change now? Because that cost you what, 180 days or so?
Yes, and 15 grand, so a lot of money that I've been saving up.
So how's that going to change now?
Obviously, I've definitely learned my lesson this time. I don't want to keep doing this over and over and being in this courtroom and feeling like I'm a failure all the time. Just want to get out there and actually be a productive member of society.
You got a sponsor for AA?
I didn't get one yet, but I was thinking of I think his last name is Ott. I was in Willoughby, but I have to move to Chesterland now. So I might have to find new places to go and possibly just get a sponsor as fast as I could possible.
Think that might have helped if you had one when you...
Probably.
Before you started to drink?
I was trying to get one, but the dude that I wanted to be my sponsor was not a sponsor. So I was trying to find the right person for me.
Okay. All right, Mr. Mack?
Judge, just in mitigation, it's not like he thumbed his nose at your probation. He was doing what you required of him. He reported regularly. He completed the 6 classes at Decision Point. He was doing 3 AA meetings per week. He completed NIOP. That was a 12-week program, 1 time a week, 2 hours a day. That took significant commitment. So he did all that you required of him, and then he goes out and he has this moment. I believe that he's less likely to violate the terms and conditions of your probation so long as he stays away from alcohol. And alcohol, of all things, he hadn't drank in 2.5 years, according to him. And his issue had been drugs. I know that he tested positive, but then he was able to change and turn that around. So I think he's generally a good probationer. So long as he stays away from those things, addresses his mental health, I think that he can do what you require of him and successfully complete your probation. So I'm asking you to give him one more opportunity, Judge.
All right. The marijuana test that was positive back in May, what was that all about?
I was at work and somebody passed me a joint and I wasn't even thinking about it and I hit it. And then that's why I came in and told Nicole about it because I knew I shouldn't have smoked it. But I wasn't even, just out of habit, I hit it a couple times and I didn't really even realize or was thinking about it. And then that's why I didn't lie about it.
What's the problem with your license?
It's suspended for life. So that's been a big damper on my mood, depression and stuff. I just wanted to really get my license back and get my life going again. That could help me out a lot, get to work every day instead of getting picked up, probably even start my own business and do better for myself.
Well, you got to figure out how you got to do it without it. I mean, it's just, that's not going to change apparently. Yeah. All right, I'm going to continue you on community control, 72 days with credit for 72. All the other terms that I ordered back in October 29th to 25, that the ongoing terms still remain in effect. So you'll get out, what, in October?
Yes, Your Honor.
Okay. And then you got to figure out how to, first thing you got to do is figure out where you're going for these AAs and then get yourself a sponsor so when this stuff arises, you got somebody to talk to.
Yeah.
All right, anything else, Mr. Mack?
No, Your Honor, thank you.
Randazzo? All right, that's it.
Thank you.
A relatively muted Judge O'Donnell so far this morning. Maybe things will get spicier later. Let's go to Florida. Wade Mercer.
Mitchell, so I'm going to ask if he introduce himself.
Jake Mitchell on behalf of the state.
Audio and video seem to be working good, Sarge?
Yes, sir.
Perfect. First case is the interpreter case, Marco Chinchilla Serrato. Mr. Ricardo, good morning. How are you, sir?
Good morning, Your Honor. I'm well. How are you?
I'm doing great. Would you please introduce yourself to Mr. Chinchilla Serrato so make sure he can see and hear you?
Yes, sir. Señor Chinchilla Serrato, mi nombre es Jordani Ricardo. Soy intérprete para que se pueda comunicar con el juez. ¿Usted me ve y me escucha?
Sí.
He can hear me and see me, Your Honor.
Great. Mr. Chinchilla Serrato, you're here because you've been accused of one count of driving with a license that's suspended or revoked.
Señor Chinchilla Serraro está aquí porque tiene un cargo de manejar con la licencia suspendida o revocada.
I've read the complaint and there is probable cause for that charge.
Leí la denuncia y hay causa probable para el cargo.
I have also looked at your criminal history and I see the same charge about 5 months ago.
He visto también sus antecedentes penales y vi el mismo cargo hace como unos 5 meses.
That charge was in a neighboring county.
Ese cargo fue en un condado vecino.
I'm appointing the public defender's office to represent you, and I'm going to ask that you listen to your attorney, Mr. McDaniel.
Le voy a asignar al abogado de oficio para que lo represente y le pido que escuche a su abogado, el señor McDaniel.
Your Honor, I spoke to Mr. Sriracha. He's going to have a plea of no contest with a charge of no valid driver's license. Understanding he'll be sentenced to 10 days in the county jail with a $400 purge that he can make after 12 p.m. today.
A su señoría, hablé con el señor Serrato. Él se va a declarar no me opongo ante el cargo enmendado de manejar sin licencia de conducir válida, entendiendo que se le va a condenar a la cárcel a 10 días con una purga de $400 que él podrá pagar después de las 12 p.m. hoy.
He understands that any plea today could be used against him in immigration court. He also has waived his right to a jury trial and call witnesses.
Él entiende que cualquier acuerdo hoy puede afectarlo en una audiencia de inmigración y también ha renunciado a su derecho a un juicio y a llamar a testigos.
Thank you. Thank you. Mr. Mitchell, is that agreeable with the state?
It is, Your Honor.
Y señor Mitchell, ¿está de acuerdo el Estado? Lo está su señoría.
And I do see on the criminal history a prior immigration action, so I'm going to ask the jail staff, have we heard anything from immigration in this case?
I have not yet.
Y en la cárcel, aquí veo que hubo acción anterior de parte de inmigración. ¿Hemos escuchado algo de parte de ellos? Aún no.
Thank you. So, Mr. Chinchilla Serrato, did you hear that agreement, sir?
Entonces, señor Chinchilla Serrato, ¿escuchó usted ese acuerdo?
Sí.
Yes.
Do you have any questions about that agreement?
¿Tiene alguna pregunta acerca del acuerdo?
No.
No.
Is that the plea you would like to enter?
¿Ese es el acuerdo que desea aceptar?
Sí.
Yes.
I'm going to accept your plea of no contest to the charge of driving while license suspended, or to the amended charge of no valid driver's license.
Voy a aceptar su declaración de no me opongo al cargo enmendado de no tener licencia de conducir válida.
I'm going to withhold adjudication of guilt and sentence you to 10 days in jail.
Le voy a suspender el fallo de culpabilidad y lo condeno a 10 días en la cárcel.
But I'm going to set a purge amount of $400, and if you pay that purge, you'll be released immediately.
Pero le voy a poner una purga de $400 y si paga la purga quedaría en libertad inmediatamente.
When I say immediately, I mean any point after noon today.
Y cuando digo inmediatamente me refiero a cualquier momento después del mediodía hoy.
So you may want to check, let your family, I don't want you to post the purge and then find out that immigration has placed a hold on you.
No me gustaría que usted pagara la purga y que después se dé cuenta de que inmigración le dio una orden de retención.
So you may want to let your family know to post the purge at noon if immigration has not placed a hold on you.
Entonces quizás le quiera dejar saber a su familia que pague la purga a mediodía si es que inmigración no le ha dado una orden de retención.
You still could post the purge, even if they place a hold on you, but you wouldn't get out. You would just go into their custody.
La purga la sigue pudiendo pagar aunque ellos le den una orden de retención, solo que en vez de quedar en libertad, pasaría a estar bajo la custodia de ellos.
Do you have any questions?
¿Tiene alguna pregunta?
No.
No.
Have a good day, sir.
Que tenga buen día, señor.
Mr. McDaniel, we do have one person that has friends or family here. Thank you, Mr. Carter.
Thank you, Your Honor.
Mr. McDaniel, I didn't write down the credit for Mr. Chinchilla. What's it, 1 day credit?
1 day credit.
Next case we have that has friends or family here is Charles Coleman. Let me see Mr. Coleman next. Mr. Coleman, good morning. Mr. Coleman, you're here on a failure to appear warning case 26-69 CF. It's a felony case number. Judge Garcia has signed a no bond warrant because you've allegedly failed to appear at a pretrial conference back on July 21st or thereabouts. Your wife is in the courtroom, just letting you know she's here on your behalf. So you do have a no bond warrant. You're going to be held with no bond. I'm going to ask Mr. McDaniel to notify your attorney that you're in jail. Usually when that attorney gets the email from Mr. McDaniel, they will go ahead and come see you at the jail because they understand you have no bond. You will automatically get put on the next pretrial conference date. Now, sometimes I have those dates and sometimes I don't. Mr. Mitchell or Ms. Williams, do we know when the next Judge Garcia's next pretrial date is, or Mr. McDaniel may know?
August 25th, maybe?
We think it's going to be August 25th, but you'll be on her next pretrial docket, but your attorney will come see you hopefully before the end of next several working days. That's August the 18th, maybe her next pretrial date, but you missed a pretrial, so you go to a pretrial docket, not an arraignment docket. Your wife has a question. Yes, ma'am.
I sat there all day. All day.
You were here in court? Come on up, ma'am. Come on up so he can hear you. And wait, ma'am, I want him to hear you. So come on up for the microphone so that he can hear you. So let me open up the file because I did look at it this morning. And just a second, ma'am. Ma'am, wait, stop talking. Let me open the file. Then I want to hear from you, but you got to be patient, okay? So give me a second here. It's 26 CF 69. And your name, ma'am? What's your name? It's okay. Stephanie
Coleman.
Okay, and you're Mr. Coleman's wife. Okay, there's nothing to be nervous about. Just give me a second because I want to be able to fully understand what you're saying. So that Mr. Coleman signed a notice to appear, handwritten, according to this court file, to be in court. And because I saw that this morning, and let's see what his court date was. July 21st at 1 p.m.
At 1 p.m.
So hang on just a second. Wait just a second. Just wait. Okay, at 1 p.m. And then the next thing that happened in the file is July 23rd, which was 2 days later. That's unusual, but what that usually means is they had court all day. So the clerk's office didn't have time to issue the warrant because they may not have got out of court till 5 o'clock. Usually it'd be issued the next day, but for some reason the day after that, a warrant was issued. Now, I can pull up on video where they called his name that day and see what it shows. But go ahead and tell me what you want to tell me now.
We had the time wrong. We thought it was the morning. So we sat up here from like 8:30 till like noon.
Okay, you just told me y'all were here all day. So you weren't here all day.
Not the whole day. I didn't realize that it was an all day thing or that it was an afternoon thing.
Okay, so let me help understand your mindset. So he's got a court date and you think it's on that day. Y'all come here and y'all sit half a day. Is that what you're saying?
Yes, sir.
And then what do? Do you ask someone, hey, is he on the docket, or do you just get up and leave?
I had to be to work at 1, so I had left. And then he called me about 15 minutes after I left and said that it was the end of the session, that they had made it to the end of the roster and that his name wasn't called.
Okay, so you didn't ask anybody, and you don't know if he did or not.
I had already left. Yes, sir.
Okay, thank you for coming and telling me that. Mr. Coleman, do you have any questions or anything you want to tell me, Mr. McDaniel, anything?
Jay, did they have an afternoon docket? Did y'all have?
They did have. Yeah, they had an afternoon docket that day, and usually whenever they finish that morning docket, which is just strictly in custody at that point, if there's anybody left in the courtroom, Judge Garcia usually does a good job of asking who they are and if they were just here for the wrong court date.
That's probably on record too. Okay, thank you. So Mr. McDaniel is going to let the attorney know what you're saying. there's a video in that courtroom. So if he was there all morning, that's something Judge Garcia or the attorney can watch and Judge Garcia can see. But also if Judge Garcia, what she normally would do, and in the doc, we're fixing to take a lunch break. She would say something like this: we're fixing to take a lunch break. If you're here for a case and we didn't call that name, let me know. And if she did that and he didn't raise his hand, there's a problem there. No, thank you for coming, but I just want you to understand why he's got no bond. She may change that today for all I know. It's her case. But right now he's got no bond.
He wasn't trying to not appear, you know what I mean? Like, that's why we were here today.
Yes, ma'am. Thank you. Thank you for coming and telling me that. Ms. Williams? We need Mr. Coleman back to ask his date of birth. Sarge.
Oh, yeah, I just noticed that too.
His date of birth, 2/14/86. 2/14/86.
Just a second, Mr. Coleman.
Coleman.
Okay, something's not matching here. So, Mr. Coleman, something's not matching. So tell me what's going on, Don. Okay, let's look and see. The warrant has 2/14/86. So the jail sheet is what's wrong. It's way wrong. Yeah, the jail sheet's wrong by about 11 years. So they just made you 11 years younger. But
So all of our
86 is
paperwork's correct except for that.
Okay.
Just,
Thank you.
Clear.
Thank you. So we're good now. Thank you. Wish you the best, sir. Thank you for coming, man. Next case is Dakota Gonzalez. Mr. Gonzalez, good morning, Mr. Gonzalez. You're here because you've been accused of aggravated battery on a detainee, Mr. Gonzalez. This warrant was signed by Judge Garcia. I did read the complaint this morning to have a little more information. She's already found probable cause. I also took a look at the criminal history, it's pretty lengthy. But I think you're entitled to a bond as far as I can tell. I'm going to listen to the attorneys before I set this bond. I believe it's a first-degree felony. Mr. McDaniel, anything on behalf of Mr. Gonzalez?
Your Honor, only I did read the complaint and looked at the complaint and, we'd ask for a reasonable bond. There is questions over identity in the complaint that was written. So we just asked for a reasonable bond based on,
I'm glad you pointed that out. I think I first appeared. Is this the case where the officers are accused of
culpable negligence,
telling the other inmates to jump on it? That's what this case is about. Yes. So in the other cases, it mentions multiple inmates jumping on the individual that got hurt.
Yes.
But in this case, this complaint makes it sound like Mr. Gonzalez was the only one. It never mentions anybody else, which is a little bit misleading. But the allegation is there were multiple inmates involved in this, not just Mr. Gonzalez. Am I right about that or am I wrong?
There is multiple inmates jumping the alleged victim in this case. I think the way after I discussed with the detective in this case, because I met with him to discuss the culpable negligence cases that we had with the correctional officers, Mr. Gonzalez caused the most damage to the inmate in this one by, i.e. curb stomping the inmate by kicking him in the head and causing his jaw to be broken.
Okay. So,
and I have reviewed the video footage and I did see this actually happen.
Thank you, Mr. Mitchell. That's helpful. But what I'm concerned about, and I think Mr. McDaniel makes a valid point. Let's see what the complaint says.
I want to say the victim.
The footage shows inmate Gonzalez approaching inmate Holland, repeatedly punching, kicking, and stopping him, blah, blah, blah. Goes on and on.
I'd have to pull
loses consciousness, unable to identify the inmate, great bodily harm. Okay, so my concern is the officer never once in this complaint mentions the state's version that there were multiple inmates involved in this attack. To me, that's leaving out something that's important. He's still legally just as responsible if the state can prove this as he would be if it was him himself. But as Mr. McDaniel points out, it certainly creates a nuance. Why wouldn't the investigator tell us that in the complaint? Simply one sentence. It's just misleading. It's not giving the judge all the information he or she needs. It's not going to affect my bond today, but it's certainly a factor to know that he may not have been the one to cause this specific injury. And it may not be a legal defense, but it's something I would like to know for first appearance purposes. If 5 people jump on somebody and one of them's arrested, I'd like to know there were 5. Just don't do a complaint and make it sound like there was 1. So it is what it is. I do not know if you finished your sentence. Mr. McDaniel, has he EOS'd his sentence in DOC, or is he still serving it?
He's EOS'd. I think he may be on probation afterwards, but he's EOS'd.
Okay. Anything else on behalf of Mr. Gonzalez?
Nothing, Your Honor.
Mr. Mitchell, anything else?
Nothing from the state, Your Honor.
So, Mr. Gonzalez, it's a first-degree felony. Given your history and it's a first-degree felony, I'm going to set your bond at $50,000, cash or surety, with a condition of no contact to the alleged victim. There shouldn't be any contact anyway. That's just something I have to do under Florida law in our particular circuit. So, no contact with the alleged victim, but you do have the right to that bond. The reason the bond is that amount is because of both the criminal history and the fact that you're accused of a first-degree felony, which is a very serious charge. You have the right to post the bond, sir. You will get to use the phone in just a few minutes, sir, to try to post that bond. And if you post the bond, you'll be released. If you're not able to post the bond, the public defender's office will be in contact with you at the jail. I'm going to ask the jail staff to give you a notice for your court date, which should be September 1st at 8:30. Mr. Gonzalez, do you have any questions?
No, sir.
All right, sir. Wish you the best. We have, I believe, Samad Johnson's the last case for the day. Mr. Johnson, good morning. Mr. Johnson, you've got a couple of other cases I've already first appeared you on, but the best I can tell, your latest charge is 1 count of harassing felony in a first or life or capital proceeding. Mr. Johnson, it appears to me, and Sergeant can correct me if I'm wrong, Judge Roberts first appeared you on this weekend, perhaps, or the end of the week, one or the other, and wanted you held 5 days. The first appearance sheet doesn't show why. I'm assuming it was to give the state time to look into whether they want to file a motion for pretrial detention.
That's what I would assume. That was my assumption. Also, Your Honor, I don't know either, and the state knows anything, but he's being held without bond and on another case, so I don't.
Okay.
Yeah, I spoke with Mr. Gill, and he said because he's being held without bond and his bond was revoked, as of right now, state's not going to file motion for pretrial detention. I can't speak for later, but it's not the intention now.
So, Mr. Johnson, the state's not filing a motion for pretrial detention in this particular charge. That means I can go ahead and set you a bond in that case, which is what I need to do. I do not know. It's a first-degree felony. What bond was set? Sarge, do you have his bond that was set in his other?
$130,000. Yeah, they added that charge to it on the 27th. They filed it in the same case number, but they didn't file an information with this charge, but they did it all on the same day when I glanced at it. So I'm assuming there's another information coming with this charge, maybe.
Okay. Since he's been arrested, I've got to go ahead and set a bond. And if they file no information, we'll withdraw that bond. I know it's $130,000 total. What I don't know is what were the bonds set, because if he's got another first-degree felony, I'm just going to set the same bond that was set on that one.
That's what it was. Yeah, he had a burglary with battery in the latest one.
100,000 on the burglary with battery.
That's the same degree crime, Mr. Johnson. Your bond in this case is going to be $100,000 cash or surety, no contact with the alleged victim. I know they've already given you an instruction about telephone contact, and be careful with that. I haven't heard any allegations that you violated that since I gave you that instructions. Just be aware of that. If you get caught talking to this alleged victim, there's a good chance that's going to stop all telephone contact, with the exception of your attorney. So, and I know that you want to speak to your mom and she wants to speak to you. So don't talk to the alleged victim. Any questions, sir?
No, sir.
Have a good day, sir. Mr. McDaniel, that's it as far as I have on my list. Anything else?
Alrighty, friends, good morning once again. TCF Live on a glorious Wednesday. We're going to go back to Judge McNally's court. Hoarder Man is in the building. He's not being called yet, though. It looks like we're doing some kind of a hearing at the moment. So let's
Can I have a seat over there? Tell me your name, sir.
My name is Dan Keith Ferguson.
Your appearance, Mr. Wayne?
Yes, good morning to you and your staff, Your Honor. Matthew Wayne on behalf of the Township of Groseal.
All right, so we have count 1. These are all violations of local ordinance. Vegetation over 10 inches on the entire property. Junk, trash, unused, abandoned objects, boats, ATVs, tires. Utility trailers, 2 of them on the property in violation of ordinance. Detailed. So with that, Any preliminary matters you have to bring up?
I believe so, Your Honor.
Any preliminary matters you want to bring up, Mr. Robinson? And you still wish to proceed to a hearing on all three of these counts?
Yeah.
All right, call your first witness. I mean, you could make an opening. Go ahead and make your opening. Unless you want to waive and he has no objection.
Waive the opening, Your Honor.
Any objection to him waiving his opening statement?
No.
You want to give an opening statement? Will you tell me what should be evidence? We'll show you have to stand up when you're addressing the court, okay?
I apologize.
That's all right.
Yeah. From my opening statement, I just want to say that, it's become a thing of, like, at first I took it as, you know, okay, cut your grass more often because it's not a thing that I do or something.
I'm sorry, it's not a thing that what?
I don't cut every 2 weeks. I may cut 3, I may cut 2, I may, you know, but I cut my grass, it stays neutral, everything's fine. With the trailer, she told me, not even 2 years ago, as long as it was behind the house, there was no issues. Now everything behind the house is an issue, everything in the driveway is an issue. It's becoming a thing where this year I'm getting a letter in the mail every 2 weeks. And every time I'm getting a letter, some of the stuff's already adjusted because it's 1-2 days. I may have a trailer there from a job and I remove it.
Well, they're saying all this happened on June the 9th. They're focusing on June the 9th.
I just want you to know it's becoming a real.
And if I went over there and it looked like a country club right now, it doesn't mean it looked like a country club on June the 9th. You follow me? We're focusing on June the 9th. Okay? Anything else?
No, thank you.
Call your first witness. Who is it?
You can call it Julie Portis.
Okay. You can come on up here, Ms. Cordes. You're gonna have some photos for me to see, right?
Yes, Your Honor.
Raise your right hand, Ms. Portis. You solemnly swear affirm on the penalties of perjury that the testimony you will give in these proceedings will be the whole truth, so help you God.
I do.
Okay, have a seat, please. You may proceed.
Good morning. How are you today?
Good, how are you, sir?
I'm fine, thanks. What's your name, please?
Julie Portis Redfield.
And how are you employed?
I'm animal control and ordinance enforcement for Rosehill Township.
And how long have you been in the employ of Rosehill Township?
14 years animal control and about 3 or 4 years ordinance enforcement.
Okay. With respect to the ordinance enforcement, tell me about your job and what you do.
Basically, I focus on the nuisance ordinances.
I'm sorry, what are those?
Nuisance ordinances are very obvious violations of, for instance, a junk car in the front yard or a boat on a trailer forward of your setback. Vegetation over 10 inches, like not cutting the grass. Like trash and debris not being managed. And typically I just observe from the road on vehicle control, but we also get complaints, neighbor complaints, citizen complaints, formal complaints through either email, in person in our office, or by telephone. And those get added to a inspection list daily. And I go out daily and take a look at those, make observations, and send my notes back to the office.
Okay. During your time as a code enforcement officer with the township, approximately how many citations have you issued for nuisance or blight?
Say on an average, I might issue 1 citation per month. It's probably less than that.
But overall, so during your time with the township, how many citations do you think you've issued for nuisance or blight?
30 or 40, 50. I'm not sure.
Okay. More than a handful.
Yes, sir.
Is that fair to say?
Yes, sir.
Okay. I'd like to take you back to on or about June 9th, 2026 in Rosehill Township at the County of Plains. Did something happen that day that brought you here today?
Yes, sir. I was actually on a 5th follow-up for Mr. Robinson's property.
If I just stop you there for a second, and where is this property?
I don't know the exact address. It's on Highland off of Meridian, between Meridian and Thoroughfare.
If I could, may I approach your?
You can.
I'd like to introduce people to proposed Exhibit A.
Do you have a document that's gonna refresh your recollection as to the address of the property?
Yes, sir.
Okay,
It'd be on the citation for one.
Yes.
The notice that was sent to Mr. Robinson, it would be on there.
so you wanted to refresh your recollection on that and
Yeah,
then
would you like to?
Yes, please. Okay. Thank you.
You're welcome. So if you want to take a look at that, please just familiarize yourself with it. Then let me know when you're done, please.
I'm done.
Okay. What am I looking at? What are you looking at?
This would be a notice that was sent on March 27th to Mr. Robinson, describing some of the violations that were observed back in March.
Okay. And what is the address of the subject property?
9215 Highland, Grossman, Michigan.
Is this the address that we're going to be talking about today with respect to the
It is.
violations alleged?
Yes, sir.
Okay. So again, we're going back to on or about June 9, 2026 in Mercer Township in the county of Wayne. So with respect to people's proposed exhibit A, what were you doing there that day and how does that correspond to this exhibit?
I'm not sure if this was the first time I was out there. March 27th was going back quite a ways. But I was there because this address was on my list for inspections that day.
Okay, I'm sorry.
Familiar with the address.
Thank you for a second. But again, so you're familiar with this notice as we said.
You gotta be kidding me. Something went south there, my friends. He never pulls a feed like that. I hope this means that he'll start over and that we don't lose Hoarder Man. Something went south. All right, let's do this while I regroup and try to figure out what's going on there. Let's go back to Judge Anzalone.
All right, are you Mr. Tyler Daniels?
Yes, ma'am.
All right, I am going to open up a breakout room. So let me call your case. These are files number 2026-22552FH, 26-22553FH. The matter of the people of the state of Michigan versus Tyler Gregory Daniels. I have Isaac Sneed appearing on behalf of people, Matthew Murphy appearing on behalf of Mr. Daniels. Mr. Murphy, I presume that you went in back because you're going to need a breakout room with your client, correct?
Yes, Your Honor, please.
And Mr. Coast, you popped in. Is there an update for Mr. Tyler Daniels?
Well, I do, Judge. We also have a show cause on him. He failed to provide me with a treatment completion discharge, also a copy of his Suboxone, and I also have him down for missing drug screens.
Okay. Well, we know where he is at this time, so we'll hold off on that for a moment. Mr. Murphy and Mr. Daniels, go ahead and join that breakout room. Oh, Mr. Getch is logged on.
Alrighty, friends, so whatever went down with Judge McNally there, he not only cut his feed, he deleted everything that was on his channel. So he had a tantrum. That's what that tells me, because I've seen him do that once or twice before, where something doesn't go right and then all of a sudden he just nukes everything. So I don't know if he got into some kind of a yelling match with the defendant or something was said, but when things have gone south in the past, this is what he's done. So something went south. Anywho, let's since Judge Anzalone appears to be between things, let's go to Texas. Judge Stevens.
He is.
Is Jessica here?
Yes,
She's standing by her attorney.
Man,
I'd like to hide
people could have stood behind him. I've
Yeah.
never seen them.
Yeah. Giles is a good
size.
cover.
This size, only this size.
In a violent situation, stand behind Giles.
Yeah, right. I'm gonna be running.
With everybody hanging on.
That's right. First step.
Seriously though, this is something that you got to take care of responsibly. You're charged in 26 CR 634 with burglary of a habitation, first degree felony. So it carries with it no less than 5, no more than 9 years confinement in prison or life imprisonment. And you are Jessica Nicole Williams. Yes, speak up so she can hear. All right. This was indicted in April. What are we doing today? This announcement.
Yeah. Speak to Mike about this. He's in trial. I just actually was saying that.
Well, I know, but he's been in trial for 3 months.
No, he hasn't.
Well, he was not here.
I might be sleeping off with.
It's in the file.
I didn't see it.
What is it?
Yeah. The offer is 7 years TDC, Judge.
Does she have a prior conviction?
Reading through the facts, I think it's very fact driven, Judge, but I'll check the files.
Oh, I see. Okay, it's burglary with intent to commit another felony, and let's see. Burglarize, and that's burglary has its own punishment situation. Just if you enter a home without somebody's permission and attempt and commit theft or another kind of crime, but here it also alleges that the defendant committed or attempted to commit or committed the felony offense of aggravated assault with a deadly weapon. Used a deadly weapon, namely a pistol, by threatening the victim by pointing it to the victim's head and stating, "You are going to die today, bitch." Well, that's not the way to enter someone's home. And that's not the.
She could have used a little bit more tact with retrieving the stolen wallet that the alleged victim.
So during the mention of it, while the victim was still on the ground. There were 2 other people there. During the commission of the victim was on the ground. One of the 3 people who was one of the 2 others with the defendant.
Yeah,
exhibited a pistol and threatened the victim. "You're going to die today." During the commission of the burglary while the victim was still on the ground, Bree chocked victim by applying pressure to her neck with one hand and slapping her on the face. Jessica, Bree, and Ebony, the 3, searched several areas of the apartment for a stolen wallet but failed to locate it. Subjects were removed from the residence and the firearm was retrieved and secured. And all 3 were placed under arrest. Okay. So I wonder how the police found out about it.
The police actually found that wallet. The alleged victim stole the wallet from the time she was sleeping in the vehicle.
Yeah, but you don't put a gun to somebody's head and threaten to kill them.
Well, yeah,
I mean, that's kind of a problem. That's no way to converse.
I agree, Your Honor.
With someone
That victim doesn't have clean hands. She lied to the police and told them that she didn't have a wallet.
So you put a gun to somebody's head and threaten them. Well, that's what the essence of this charge is. Maybe they're going to charge something else, but right now you're charged with burglary of habitation. And just because they find the wallet somewhere else or it's found, it's burglary of habitation. I mean, you entered somebody's home without their permission and then put a gun to their head according to the probable cause affidavit. And that's pretty serious all the way around. I guess that's why the offer is not a probation offer. So put on trial. All right. Set it on the job offer. That's what we're going to do. And don't have, ma'am, here's one of the conditions of your bond. You can't have any contact with the victim. Okay. No one on your behalf unless the court approves it. So don't. And that's what's happening all the time up here. These side things are getting made, and it's against the rules. But I'll just warn you. Yeah, Tom.
Ms. Moreno.
Well,
he was in county court number 2.
Why?
Ms. Moreno.
Why?
He was in county court number 2.
Why? He's supposed to be in here.
Well, he has some.
Oh, we had something over there.
Yeah, they tell
Oh.
him.
Does he need to get a? She needs to get a reset.
And they tell him to report there first and then come to the felony. They called me and then I told them.
Oh, ma'am, no, I need you to sign it right here on that.
It's chaos today. It's chaos.
It's CDC, Judge.
Have you retained Mr. Burbank? Have you paid him? Need to give him that chain. Seal the deal. As it was. On Marino, what are we doing? It's done. You're looking at a 3rd-degree felony up to 10 years in prison here. What are you charged with in misdemeanor court?
He was on probation whenever this offense was.
Oh, it's a probation or everything? What's he on probation for? Yeah.
That's correct. It is a gun charge.
Okay.
Trial docket.
All right. That's what we'll do.
We need some consideration in what you did prior.
I don't.
Where you raised Devin development.
That's all. He's here. Yeah, it's all that revoked.
Okay.
He's back in the way it was before those findings because he wasn't here. He's here. He's purged. He's purged his sin. He's good.
Be excused, Judge.
Yes. Get a resetting. Jasmine Daniels.
So while we wait for Jasmine Daniels, a thank you to Austin. He looked this up. Horderman has been seen by Judge McNally, and he has been given another 5 days in jail, according to the court documentation that's available online. So thank you, Austin, for finding that. Again, Horderman, 5 more days in jail, and we'll try to keep on top of his next visit.
Into trial, and y'all are going to have to wait until noon. Good luck. But we got a trial we got to finish. Kevin Jefferson, where are you? And Comerford is your attorney too? Okay. He's not here. We got to wait until he gets here, but we're going into trial in a little while. Y'all are going to have to wait. I'm moving forward. He's not in this room. That's what counts. I'm not going to him. Does Burger King come to your house? No. James Hoskinson. Hey, Brian Lynn's case was reset on Taylor Jackson. Brian?
Yes, let me.
Okay.
Mr. Hoskinson.
Hoskinson. There's a sentencing on one of Comerford's cases. Okay. You know what you're charged with? State jail file. What are we doing?
Judge, we're just asking for one last announcement date. We've got the discovery, we reviewed it, we're just making sure we've got everything in order. Try to
3
resolve
weeks,
the case
good?
the next time. That was sufficient.
It was 3 weeks.
Thank you, Judge.
Okay, get a reset. On Taylor Jackson, where are you, Taylor? Jackson?
Sorry.
On this one, I've got a note here, but is the defendant supposed to be here?
No, Judge, Mr. Lane.
I know, but is the defendant supposed to, was the
No.
defendant supposed to be here? Okay,
He'll be here next week.
which it was on my terms. Cyrus. Fun enough. Okay. And it's announcement.
Yes, Your Honor, could I have 3 more weeks? I need to finish going over everything in this.
All right, 3 weeks. You got it. Devin Young. 2 places.
Here, Your Honor, in the same announcement.
3 weeks, you said?
Yes.
You said 3 weeks. Gonna reset things. Odd one on Austin Mentis.
Yes, Your Honor. Yeah,
You okay?
Debatable.
And always.
Who's on? You.
Good morning, Your Honor.
Hello. All right, in 26 CR 973, you're Austin Mentis, charged with a 3rd-degree felony of what's called child grooming here. And then there's a prior felony offensive robbery, a conviction out of Gregg County. If you were found guilty of this 3rd-degree felony, and this was proven true on the prior conviction, this becomes a 2nd-degree felony punishment up to 20 years in prison. So you're not eligible for probation if this prior conviction is indeed valid. And what's this announcement?
Yes, Your Honor. This is the first setting. There's documents and records that we must review. We haven't had the opportunity. I want to make sure all of that is done. Then we're asking for a reset and we'll come back and make an announcement.
You got 3 weeks, okay, to get it?
3 weeks?
Yeah.
Yes, sir.
Anything else on this?
No, from the state.
Okay, there's a motion to quash the indictment that was filed. And did you want to delay that defer that to another time?
Yes, Your Honor.
Because I'm looking at the elements of the offense are included in the indictment. So, okay. Well, we'll deal with that later.
Okay.
We're resetting. And Christopher Baker, that's not yours. No attorney. Defendant to hire attorney. You're Christopher Baker?
Yes.
You're charged with a 3rd-degree felony. Obstruction of retaliation. Threatening to harm another, namely person, threatening assault in retaliation for or on account of the status of that person you threaten is a public servant, namely a Port Arthur police officer. And once this is about as disgusting as it gets in the allegations of the wrongdoing. Nothing good happens at 1 a.m. Seems like. You've also got a misdemeanor case pending as well.
Yes, sir.
Who's representing you on that?
I got to put in 20, November.
All right, well, we don't wait, we move forward.
Yes, sir.
You have to get a lawyer.
Yes, sir.
And
so
it's been 2 months. And you need to get a lawyer. What are you doing about that? Because you make a mess. If you make a mess, charged with a mess, just like everybody else, we have the responsibility to fix our messes. That means it's going to cost. It always does. Anybody in this room, it costs. That's why you don't want to be in this room for any other reason, but it costs money. You got to, and you can represent yourself, which would be a very foolish maneuver. That never seems to work.
Yes, sir.
You got to get a lawyer. That means you got to talk to people. Who have you talked to?
I talked to Langston
Adams.
And talked to forgot the other ones.
There are about 250 lawyers in this county.
Yes, sir. But I've been looking around, but while I work it, we haven't been having any votes coming in. So I have been funds to purchase one, and I wanted to know if I could report it anyway.
I'm a taxpayer. I don't want to pay for you.
Yeah.
For your mess. And that's what the taxpayers think too. They're paying you. If you're charged with a mess, you, like me, we all have a responsibility to fix it.
Yes, sir.
That's why I had 3 jobs growing up, because if I made a mess, I wanted to be able to be responsible. I didn't want somebody else paying for what I allegedly did.
Yes.
And
Judge, I do need to amend the indictment on small matter. They put the officer's first and middle name. They didn't put her last name. It's Jeray Jamel Lewis, Lewis. We would ask to amend that to add Lewis at the end on her name. Excuse me.
okay, let's think law school. Is that the way to do it?
I mean, I can re-indict it.
Because it's a surname. I'm not sure if you
I'll just
adding
re-indict
it.
I'll just
passes-
re-indict it.
I think that's what is probably
I'll do it.
the cleanest way to do this is to amend it through the grand jury, so that there's not a problem later. Since it's a
Since they put first and middle name.
I know, but the surname is seems to be the most important by law, but that's a better idea though, Mr. Logan.
Okay.
I'm gonna reset this for 3 weeks, but your name does not include your surname, and he's gonna present it.
The victim's surname, the complaints.
I'm sorry, Crystal.
Jamel Duray, it should say Jamel Duray.
I'm sorry, the victim, the officer that's allegedly threatened here.
I'll take care of it.
Okay, victim and defendant, the names should be corrected if possible, and we'll reset this for 3 weeks. Thank you. All right, who's left? Who do we have?
First case.
Jasmine Daniels and Kevin Beckett. I don't have it. I don't have Daniels.
I think that's.
I have a file for Don Deucer.
No. Look, yeah.
Where? This is Kevin Jefferson. This is Kevin Jefferson, which is his other
This is
case.
Jasmine Daniels, yeah.
Jasmine Daniels.
The wrong file here.
Well, where is, if I'm doing that, where's Don Deucer? He's not even on the docket.
Judge,
Let's see him.
when we print
What's
these,
this one?
when we print these labels, sometimes
Okay.
the attorney changes and we don't reprint the labels.
But you're retained on this?
Yes.
Okay. So Don Deucer's no longer your lawyer? Okay. And you were charged with the third-degree felony evading arrest or detention with a motor vehicle, which carries with it up to 10 years in prison. Serious. What are we doing today?
Judge, I've just gotten the media footage. I still need time to review that. I'm getting some more medication material from Ms. Daniels, and so I'm gonna need another, at least a 30-day reset.
You got in May?
Yes.
Looks like Brent Turk was on it before. 3 weeks, did you say? Or
At least 30 days.
yeah, 4 weeks. You got it?
Yes, sir.
The Kevin Jefferson. Oh. This is sentencing?
Yes, Judge.
Mr. Jefferson. All right, we now call cause number 25 CR 961, the state of Texas versus Kevin Jamal Jefferson. That's you. Correct?
Yes.
And Comerford is here representing you. You were indicted for this operating a motor vehicle while intoxicated. Do you happen to have the pad on that one for that case? He pleaded, it looks like he pleaded true to the second paragraph, which constitutes the two or more prior DWIs that makes it a third degree felon. But he's got 2012 two burglary of habitations, but he did not plead true to that, right?
Correct, because what we were
So
doing,
we're just at a third degree felony?
we had an agreement as to him being placed on probation for 10 years. Sentenced to 10, probated for 10 with $1,000 fine. The PSI was to determine what drug treatment the state's position was safe being. They wanted something other than that, Judge.
They mentioned JCDI in the PSI, Judge, and so that would be a program I think that Mr. Jefferson could benefit from. That would keep him to support his
He
children.
could benefit from it. They all could. They don't all do it. They all don't benefit, but I've got. So in 2010, he was placed on deferred probation for burglary of a habitation, and then that was revoked. He got 11 years in 2012 for burglary, second degree felony, and then evading arrest. His probation on April 10th, 28th of 2010, 5 years before that was revoked, and he gets 2 years on October 8th, concurrently with the burglary. And then there's a second burglary conviction on October 8th, and he's sentenced to 6 years. Is that what happens? Yeah.
Yes, sir.
So he's got 2 burglary convictions, which are, I guess, represented in, yeah, those paragraphs 3 and 4, plus a evading arrest. That was that state jail.
Yes, sir.
And so the plan is to convict, he's going to be convicted on this one. But this is a regular probation, which means next time you'd be looking at habitual felon status, 25 minimum. You still have a long way to go in life, but 25 years, a quarter of a century, can really foul up freedom. Okay. Y'all had a chance to review the pre-sentence report. Any corrections or changes to it?
Yes, sir. No corrections.
Awesome. Nope. All right. Anything else to add? We're going to get to this. I'm going to make my findings, follow the agreement of 10/10, and then y'all get to be heard on what additional conditions you think might be appropriate.
Thank you, Judge.
I'll consider that. Okay. All right. Mr. Jefferson, we are here earlier. Again, you pleaded guilty to operating a motor vehicle while intoxicated. And you pleaded true to paragraph 2 prior DWIs, operating motor vehicles while intoxicated. Thus, this third one becomes a felony if all of that is true. You pleaded true to paragraph 2, which actually you have 3 prior DWI convictions, not just 2. But 2 or more elevates a regular DWI to a 3rd-degree felony. So you were looking at no less than 2, no more than 10 years confinement in prison, and a fine up to $10,000 could be assessed. And this court is going to make its findings. Did anybody want to add anything more? If nothing further, I'm going to find that you have pleaded guilty to paragraphs 1 and 2, and true to paragraph 2, which constitutes the prior convictions, which together turns this operating a motor vehicle in a public place while intoxicated to a 3rd-degree felony, because it's your 3rd conviction of a DWI or greater. You have pleaded guilty voluntarily. You were mentally competent to do so. You understood and appreciated the consequences of pleading guilty. There's sufficient evidence supporting your guilty plea from State's Exhibit 1 admitted at the hearing right here, supporting your guilty plea to find you guilty beyond a reasonable doubt. And I find that you are mentally competent to enter this plea. You are guilty of this offense and any lesser included offenses, and you are giving up your rights to a jury trial and the rights to the appearance, confrontation, and cross-examination of witnesses. I am following this agreement. You were hereby found guilty beyond a reasonable doubt and sentenced to 10 years imprisonment. That sentence is suspended. You are placed on regular probation for 10 years. You will be fined $1,000. There will be terms and conditions of probation, which are normal and customary for this type of offense. Also, the state is recommending that you receive substance abuse felony punishment facility assistance, which is it's really kind of like a hospital-like environment that seems to be quite effective for folks. This is something that the state is requesting, and I want to hear what the defense says, but you have bypassed this level for felony as for DWIs 2 convictions ago, you know? So you've been placed on supervision 3 times, all of which resulted in revocations. So, as the probation office states in the pre-sentence report, this reflects a pattern of non-compliance with court-ordered conditions. Overall, the defendant's history reflects a recurring pattern of impaired driving and poor judgment, suggesting long-standing alcohol use issue that has remained unaddressed. Despite repeated involvement with the criminal justice system, the defendant has never participated in the substance abuse treatment, therefore has not had the opportunity to learn the skills and tools necessary to address his alcohol abuse or break this recurring cycle of behavior. As such, the defendant may benefit from structured substance abuse treatment to address the underlying factors contributing to his criminal conduct. And also, it should reduce the likelihood of future alcohol-related offenses. All of that I find to be accurately stated. I intend to place the defendant on community supervision. Now, what is it we want to add to this? The defendant, according to the probation office, should participate in an intensive outpatient treatment, specifically the Jefferson County Drug Intervention Program, in accordance with the recommendations of the licensed chemical dependency counselor. And should the defendant test positive for alcohol or controlled substances while participating in JCDI, he should be required to enter and successfully complete the substance abuse felony punishment facility, SAFE, as well as all required aftercare components. So the probation office has designed a method of stair step. They're suggesting JCDI, then SAFE, but this court, if I place you on JCDI, you failed, I don't have to put you in the SAFE program. We can go right to prison, which I don't know how many more chances you get about finger pointing on this is a 4,000-pound missile you're operating irresponsibly around town. If you don't care about your own life and well-being, you ought to care about other people who trust other drivers to be responsible for their lives, which you don't show. Here you were twice the legal limit, over twice the legal limit for impaired driving and being intoxicated. All right, go ahead, state.
Judge, my original offer on this case was 12 years TDC, or he could do 10 over 10 with safety. I told the defense counsel specifically there were no other probation options. When we appeared here in court, they signed up and I thought they were accepting that deal, and I didn't find out until we were right at the edge of completing that plea that they hadn't agreed to safety. So thus we're here.
Well, I
went through with it. I don't like how it happened. I don't feel like it was appropriate, and I'm voicing that now. That being said, looking at this PSI, you can understand why my position was that from the beginning. This man could have been treated with a second-degree felony because of his prior convictions. He does not seem to get exactly like what they said here, the concept of not drinking and driving. The 3 prior DWIs he had were they were separate dates. They end up with revocations resulting in right at the same time because he didn't successfully complete his probations. But the end result is he's drinking again, and that's 8 months after he's sentenced to time on this issue. What's really a glaring thing in this report, from my opinion, as to why he should be sent to safety, comes on page.
On this offense, how long were you out of custody before you committed this new offense?
Can't be more than 8 months, Judge.
Is that what everybody thinks that?
Maybe 8 months.
I have no idea how long he actually served on that 120-day sentence. So I'm going to give him the benefit of the doubt, say 8 months. When he gets to the going to do the substance abuse evaluation.
That's not 120 days. That's 4 months.
I'm talking about between the sentence date and this new offense date from his priors.
How much time were you in custody the last time you were disciplined for DWI? Mm-hmm. Okay.
So when we look at page 4 and the substance abuse evaluation that's done, the lady that conducted this, Ms. Posey, noted that he underreported his consumption and mood altering substances. When she went to perform a urinalysis, he claimed he was unable to provide a sample. Miraculously, when he showed up for his PSI interview a week later, he's ready to do a test. To me, I treat that as a failure. I'm not even asking that you test him today because he shows up prepared just like he did on June 10th. He needs structured help. And that's the whole reason why I was willing to give him probation with safety. I understand what they're suggesting as far as JCDI and the stair step there. And I would agree with that if someone didn't have his history. But with his history and these facts, I would feel safer for Jefferson County and our community that he doesn't leave this courtroom. He goes from here into custody and goes into safety.
Okay, from Alec.
Yes, Judge. Regarding the June 3rd and June 10th instance, he had showed up on June 3rd and told Ms. Posey that morning, the first thing, that he could not use the restroom at that time. Instead of having him wait on June 3rd at the end of this evaluation, she told him he needed to come back on June 10th to do this. So he was prepared to do this on June 10th. Also, Mr. Jefferson has been employed at the port and has been taking.
Well, there's a lot to lose here.
His job was finished, and so he has to switches to new jobs once the project is complete. And during that time, he was being drug tested. And so he has been passing his drug tests while he's been out on bond for this case. And so he's been clean. And I think this June 3rd instance was a misunderstanding. I wouldn't say it was necessarily bad faith by Mr. Jefferson to hide the fact that he wasn't going to be unable to pass a drug test. That's not the condition now. Back then, it's not the condition today. If he would pass a drug test today, you would like him to take a drug test. I think JCDI would be most beneficial for him. He has 3 kids and he supports them right now. No other source of income would provide this family for the time that he's in safety.
Okay. All right. I'm willing to go along with the probation officer's recommendation on JCDI. But you got another problem with me, is you don't commit subsequent crimes and don't pay a price. The last time you did this, you got 120 days in jail. This time you're going to get 180 days. Each time you commit a crime like this, it's going to be more serious. A condition of probation, it will include 180 days in the county jail. Then when you leave there, then you go do JCDI. But you don't commit the same wrong act and not pay a higher price. But putting aside everybody else on the road who's at risk, my goodness, you have responsibilities at home. You're supposed to be a role model, set an example, but you know that committing crimes subject you to confinement. And how's that working out for the family unit? Just leave it. This is the event on May 17th of 25, huh?
Yes, sir.
Okay, and you're arrested at 1:05, being over double the limit, right? Yeah, at 1:05 a.m., you're intoxicated? Why aren't you at home with the family that you're so worried and concerned about? You're drunk, driving a third DWI, and the family now you're worried about was at home waiting on you. Can you explain that? If they're so important in your life, why aren't they ahead of your own drunkenness in importance? And the other people who have to share the roadway with you. There's the problem right there. You got to quit being selfish and putting your life ahead of others. And then when you come before the court on this, the first thing you want to do is, I've got children at home that I'm responsible for. Yeah, you are. But this isn't the way at 1 o'clock in the morning on a third DWI. That's no way to, you got to show responsibility, not talk about it, nor use them as a defensive mechanism to prevent you from being held accountable. All right. So you're sentenced to 10 years in prison. That's suspended for 10 years, fined $1,000. You must serve 180 days in the county jail. Then you will complete the JCDI programs. Among other things, there will be other terms and conditions of probation that the probation office will go over with you. I have them in here, right? I believe so, yes. They're awesome. $180 days. There's the problem. I can pull this white out faster than Billy the Kid could draw his gun. I use it so much. Is this? What is this one? Do I sign that? JCVI. Okay. All right. All right. Do you understand what has happened today, Mr. Jefferson? Yes. Good luck to you. I'll see you. You run out of it. Look, I got children, I got grandchildren. I can't imagine hurting them. Okay. And that's what's happening when you're in jail. But you decided that what you wanted to do was more important. That's fixable. You say you love them, show it. And it makes you a better person in life. All right. That is all. Good luck to you, sir. Here.
Alrighty, friends, TCF Live coming up to a close of hour 2. We're going to take a few minute break because I think we've earned it today. We're going to take a look at our bear friends from Alaska. I'm going to let this play for a few minutes. I encourage you to get up, stretch your legs, zen out on this for a few minutes, and we'll come back to court shortly. But let's just take a moment or 5. Okie dokie, friends. Having shed half of our viewers, happy to have the half of you that remain. I hope you enjoyed the Bears. Go to Michigan, Judge Aquilina.
This is docket 25-5183-FC. People of the state of Michigan versus Adrian Davis. Counsel, your appearance for the record.
Good morning, Your Honor. EPA Bart Buxton on behalf of the people of the state of Michigan.
Good morning, Your Honor. Toby White on behalf of Mr. Davis. Mr. Davis is with me at the podium.
Thank you, sir. Please raise your right hand. Do you swear or affirm the testimony you're about to provide will be the truth, whole truth, and nothing but the truth under penalty of perjury?
Yes, ma'am.
Thank you. Put your hand down. Sir, have you taken any medication yesterday or today?
No, ma'am.
Are you supposed to be on medication you're not on?
No, ma'am.
Any sign of fever, COVID, or other illness?
No, ma'am.
And you've had enough time to speak with your attorney?
Yes, ma'am.
And are you employed?
Yes, ma'am.
And what do you do?
DoorDash.
Okay. Did you graduate high school?
Yes, no, I got my GED.
Same thing, that's good. We're good. All right, good for you. Okay. And you're a US citizen?
Yes, ma'am.
And you are still living in Illinois?
Yes, no. I live on Lindcott.
Let me see if I've got that here. Oh, so Lindcott, you've got that here on the
Yes.
rights. All right, very good. And who do you live with?
My wife.
Okay. Good. And at the time of this offense, were you on probation, parole, or bond on another file?
No, ma'am.
All right, very good. And you had enough time to talk with your attorney. I understand there's going to be a plea, is that correct?
Yes, ma'am.
Did anyone force, threaten, or coerce you into this agreement?
No, ma'am.
Anyone promise you anything other than the agreement?
No, ma'am.
You've made the decision to plea of your own free will
Yes, ma'am.
after talking with Mr. White,
Yes, ma'am.
and you've been satisfied with his representation?
Yes, ma'am.
On behalf of the people, what is the plea agreement for the record?
Yes, Your Honor. The defendant be pleading to count 2, weapons, firearms, possession by a prohibited person. Upon successful plea and sentencing, count 1, count 3, count 4 will all be dismissed. And the habitual 4th will be amended to habitual 2nd offense status. There is an agreement in this case, Your Honor, where the parties agree that the defendant will be sentenced to cell F1 on the applicable E grid, which we have calculated at 9 to 28, with any upfront jail to not exceed 1 year. And the defendant agrees to and will receive a term of probation as part of sentencing. Any restitution will be determined at the time of sentencing. And it was not included, but obviously under statute, any weapons or contraband will be forfeited.
Thank you. Mr. White, fair, accurate, and complete?
It is, Your Honor.
And you are in agreement, counsel, with the net. It would be an F1 on the E grid in 9 to 28 months, regardless of how it comes out.
Yes.
If it's different.
Yes, I agree with that stipulation, yeah.
Okay. And so you understand that that grid may be different. It may be higher, it could be lower. I have no idea because they come out all different ways and then we argue about it later. But the agreement is that it would be the 9 to 28 months grid. Does that make sense to you?
Yes, ma'am.
So here's the thing, is there's all these factors and we're stuck with living with how they calculate these. So sometimes, as in your agreement, there's an agreement of counsel that regardless of how they come out, higher or lower, okay? I can only sentence between the 9 to 28 months if I give you to jail, okay? I don't have to give you any jail. If I do, there's an extra agreement that it cannot be more than a year.
Yes, ma'am.
Okay, so, and I just tell you that so you understand that if it's lower, because it could be, I don't know, 6 to 12 or something like that, and you might turn to us and say, hey, wait a minute, what happened here? This is just part of the agreement, and hopefully I don't have to give you any jail, but you have a right to understand up front that's part of the agreement regardless of how the numbers actually come out.
Yes.
Does that make sense? Okay. Counsel, I stated that correct?
It is. You did.
Thank you very much. And counsel, are you waiving reading of 1, 3, 4 in the habitual court?
I am.
And I don't remember if I asked you, but sir, after having said all of this, you've been satisfied with the representation of Mr. White and you want to proceed with the plea?
Yes, ma'am.
All right, very good. On behalf of the people, as to count 2.
Yes, Your Honor. People of the state of Michigan versus Adrian Keon Martrail Davis, State of Michigan, County of Ingham. In the name of the people of the state of Michigan, the prosecuting attorney for this county appears before the court and informs the court that on the date and at the location described below, the defendant in count 2, weapons, firearms, possession by prohibited person, on or about July 23rd, 2024, at 812 Baker Street, Lansing, Michigan, 48911, Ingham County, State of Michigan, the defendant did possess a firearm and is ineligible to do so because he or she had been convicted of larceny from a person, a specified felony that is punishable by imprisonment for more than 1 year, and the requirements for regaining eligibility had not been met, contrary to statute. This is a felony that is punishable up to a maximum of 5 years and or $5,000 with mandatory forfeiture of the weapon or device per statute. As I stated, the plea is also going to be to a habitual offender second. Take notice that the defendant was previously convicted of a felony or an attempt to commit a felony in that on or about December 9th, 2009, he or she was convicted of the offense of possession with intent to deliver a controlled substance less than 50 grams in violation of 333.74012A4 in the 30th Circuit Court for Ingham County in the state of Michigan. Therefore, the defendant is subject to the penalties provided by statute, that being 1 1/2 times the maximum sentence or primary offense or a lesser term. The maximum penalty cannot be less than the maximum term for a first conviction, with the maximum count 2 being 5 years. That would make this 7.5 years as the maximum. Court shall order law enforcement to collect DNA identification profile sample before sentencing or disposition, if not taken at the time of arrest, and against the peace and dignity of the state of Michigan.
Sir, did you understand what was just read? So you understand weapons, firearms, possession by a prohibited person normally is a 5-year felony, but because of the habitual second, it is 1.5 times. It's going to be 7.5 years. So
if I may, if you understand, that means that you're on probation and you violate that, the Department of Corrections could hold you for up to 7.5 years, but first you would have to create, you'd have to violate probation such that this judge ordered you to go to prison.
if things go really wrong, you're subject to up to 7.5 years because there's that habitual.
Yes, sir.
Okay, hopefully everything goes right, but it's a whole lot better than your mandatory 25 years.
Yes, sir.
Well, it looks like you all returned for a complete agreement, so hopefully everything will continue to go well. All right, and it looks like you signed the advice of rights form. Did you read it before you signed it?
Yes, sir.
Did you understand what you read?
Yes, sir.
If you had any questions, were you able to ask your attorney those questions?
Yes, sir.
Do you have any questions about your rights at this court?
You have to be audible.
No.
Okay, we're making a record, so I just need you to be clear in your answers, because if you want to appeal if something goes wrong, the record that you appeal from is the record she makes, and she can't guess your answer. So I just need you to make sure that you, instead of nodding your head, you say a word, okay?
Yes, sir.
All right, very good. And counsel, it looks like as to the dismissed counts, I don't know if we made a record of this, but if there is, first of all weapons will be forfeited. I don't know how many there were. There's a couple of other counts of firearms that were dismissed, but in regard to the count 1, if there's any restitution, that would still count.
And that is marked in the sentencing agreement.
Okay.
Or the
It was.
So, sir, in the event the victim wants restitution for any personal and property damage, and you disagree with the amount asked, then you let your attorney know, and we'll have a hearing, and I will make a decision based on the evidence. The amount can go up, it also can go down. And I don't know at this point if they're asking for anything, but they do have a right to ask for restitution. Do you understand that?
Yes, ma'am.
All right, very good. Sir, as to count 2, weapons, firearms, possession by a prohibited person, how do you plead?
Guilty.
And sir, the agreement is that I sentenced you. There's a cap of 1 year, so I could decree anywhere from 0 to 12 months. If I gave you prison time up front, then I would allow you to withdraw your plea in this manner, again, go to the pretrial stage. Or if I sentence outside the 9 to 28 months, if I gave you more than 28 months, I would allow you to withdraw your plea, because I would be violating your agreement. So if I do something that's not part of the agreement, you can withdraw your plea. First of all, do you understand that?
Yes.
However, if you violate the law or bond conditions, it nullifies this agreement. I can do what I see fit. Do you understand that?
Yes.
All right. Now, I understand there's some unique circumstances, and your attorney's going to ask you some questions to provide the factual basis for the count that you pled to, and then prosecutor or I may have additional questions. Do you understand?
Yes, sir.
If you need us to rephrase or repeat, please let us know. Mr. White, you may proceed.
Thank you, Your Honor. Mr. Davis, I'm going to call your attention to July 23rd, 2024. That's 2 years ago, almost to the day. And at that point in time, do you recall the location you were at?
I was on Baker. I don't know the address.
Okay. You were in Baker Street. Baker Street's in the city of Lansing, the county of Ingham, correct?
Yes, yes, sir.
Okay. And at that point in time, you had, as we outlined before, you had previously been convicted of a drug offense on or about December of 2009.
Yes.
And that meant that you were not allowed to possess a firearm.
Yes.
You had not taken any steps to have your firearms, ability to have firearms restored.
Yes.
And nonetheless, at that time, when you were on Baker Street, you did have a firearm in your possession for a brief time or whatever, but it was in your possession. You had, you had control of the firearm.
Yes.
Thank you.
And sir, if I told you it was 812 Baker Street, does that sound about right?
Good. I don't know the address, but yeah.
Okay. Our counsel stipulating to it being 812 Baker Street, so we don't have to amend the value information.
The people would stipulate, Your Honor.
I'll stipulate.
All right, very good. And you would agree that a firearm is a dangerous weapon?
Yes, ma'am.
On behalf of the people, any additional questions?
The people are satisfied, Your Honor.
All right, thank you. Sir, the firearm that you had, was that yours or was it somebody else's that you had in your possession, but they lawfully had it or owned it?
There's somebody else's.
Did they lawfully own it as far as you know?
No.
Okay. If they did lawfully own it, if somebody else had a license to have that, they could claim it, but it's going to be, any weapons and contraband found is going to be forfeited today. But I always make a record that if somebody, you know, if it was your grandmother's or your grandfather's or, I don't know, your neighbors, and they lawfully had it, they could go and claim it, but you can't. Does that make sense to you?
Yes.
All right, very good. Are counsel aware of promises, threats, or inducements other than those already placed on the record?
No, Your Honor.
No, Your Honor.
Has court complied with the courtroom?
You have, Your Honor.
You have?
I find defendant's plea has been freely, voluntarily, knowingly, and understandingly made without undue influence, threats, coercion, or promises of leniency. I also find there are sufficient grounds to accept defendant's plea. Therefore, count 2 will enter counts 1, 3, and 4, and the habitual 4th are dismissed, and count 2 will go forward with the habitual 2nd and the amended information. Any outstanding warrants, if any, are hereby recalled and dismissed. All weapons and contraband are forfeited. The no contact order with the victim, Anthony Vandermoor, Vandermoere, will continue. And the victim was contacted and was part of this plea agreement, or at least there was an attempt made.
The people did contact the victim, Your Honor.
All right, thank you. And your sentencing date?
September 16 at 9:30.
Does that meet with your schedule, counsel?
Being mostly retired, it should. Let me check. When is that?
September 16th at 9:30.
Sir, keep your hands up. It's my own. Thank you. That works, Your Honor.
All right, very good. So, sir, we're gonna give you that purple sheet there that has the sentencing date today. And you can also call if you don't have time today, but within 24 hours, you need to make an appointment with probation. But while you're in the building, if you would just go downstairs, hit G in the elevator, and
If I may, Your Honor, I'll walk him down.
great, and then you'll make that appointment there, and you'll need to keep that appointment. If you're sick or something, you need to change it, you change it with them, they don't. Yeah.
Just to check in for
It's-
PSIR and the interview that they're gonna
They're
schedule.
gonna do an interview that has, it's a pre-sentence investigation report that has your background, a lot of information about what happened. And that will help you be fully informed at the time of sentencing. You must do that. If you do not do that, then I have a standing order that law enforcement picks you up and they hold you in the jail until it gets done. So don't make that happen.
Yes, ma'am.
Okay, so go down, make your appointment, keep it. Something happens, you're sick or something, you change it. Don't just ignore it and wait for them to call you.
Yes,
Do you have any questions?
No.
And you understand the no contact order with the defendant?
The defendant.
I'm
Yes,
sorry,
ma'am.
with the
Yes.
victim?
Yes,
Okay, is the victim someone you knew?
No,
Okay, so in that situation, if you didn't know him, but if you recognize him or he recognizes you like at Myers, you just do an about face and leave. Just don't say a word, just leave.
yes, ma'am.
All right, good. Thank you. That's all for the record.
Thank you, Your Honor.
Alrighty, friends, hour 3 of TCF Live. During that hearing, Spec left us a $2 super chat. Thank you for that, Spec. Let's stay in Michigan. We haven't been here in a while. Let's go to Judge DeSanto.
Good morning. We're just waiting for your attorney to comment.
Should they, you have Mr. Shaw's file up there, right? I count. I gave it to you. We waited for.
Mr. Westmoreland?
You'll let me give that to you. Yes.
What county? I mean, Rick's read from that.
Just a requirement, you'll be right down.
What's that?
Just a requirement, you'll be right.
Okay, well then, okay. Let's go on the record in the matter. Can you please then have the prosecutor come in on this one, please? This is the matter of the city of Wyandotte versus Jeremy Shaw, 26835.
Thank you.
Richard P. Serrano, PhD. Your Honor, today I appear as MIDC counsel on behalf of my client presently housed in Wayne County Jail. Sir, please state your name for the record.
Jeremy Dwayne Shaw.
Okay, good morning, and appearance for the people, please.
Good morning, Your Honor. Kevin Kuzniak, 85417 for the people.
Okay, thank you. And today is the date scheduled for the pretrial in this matter. And so
Yes, now the people are moving to Nolly process matter. I have attempted to reach the victim by mail and phone in this matter and I've had no response to date. This matter also involved, a broken telephone that, the defendant was paid for. And, he also has spoken with his wife, who is the alleged victim, who said she didn't want to proceed, but I haven't heard that from her myself.
sir, when did you speak to Ms. Shaw?
Hey, what?
When did you hear that from Ms. Shaw?
Who, me?
Yes, you.
No, I never said anything about me hearing that.
Oh, maybe that
My
was
wife was supposed to
misunderstanding
go
on
to the
that.
courthouse. I know that. I was told my wife was supposed to go to the courthouse and tell the courts that, because it was my phone. It was never her phone. It was broken. It was my phone. It was broken.
Yeah, Mr. Shaw.
They're doing an
Sir.
argument.
Sir, you're going way beyond my question.
Okay.
So you haven't spoken to your wife?
No, ma'am.
I had not heard that either, Your Honor. That's not true. I don't believe it, but we go custody, obviously.
Yeah, that may have been a misunderstanding.
That's okay. There's also a written statement by Holly. You don't see it attached to the report. And photos of the phone. And apparently she had a cut on her ring as a result of the shattered phone.
We will take it up.
I did attempt to reach her at the previous pretrial by phone, and in the meantime, sent her a letter and call her again this week, and I have no response from her.
Okay.
We have no objection, no, Rocker.
All right, this matter was previously adjourned from July 1st, so a prosecutor could reach out to the victim. Prosecutor's not heard back from the victim, they're moving to no late pros. Court will grant the motion. Sir?
Yes.
You should really think about your choices and your behavior, especially since you're on felony probation, sir.
Yes, I have psychological issues with bipolar, which I don't blame for my issues, but it affects sometimes when I snap like that. I don't think, and I'm on a medication right now, and as long as I'm taking my medication,
Okay, make sure
I'm
you're
very-
taking,
I'm very
sir,
active.
make sure you're taking your medication as ordered.
Yes, ma'am.
Have a good day.
You too.
Thank you. All right.
Thank you.
And then we are recalling the matter of the city of Wyandotte versus Ashley McFall, 26735.
Good morning, Your Honor. Attorney Corey Westmoreland, on behalf of Ms. McFall. Ms. McFall, would you please state your full name for the record?
Ashley, Renee McFall.
All right, good morning. And today is the date scheduled in this matter for the pretrial and counsel.
Yes, Your Honor, at this time, the city attorney has offered to amend the original operating while intoxicated from one count of operating while visibly impaired.
Okay, how am I not seeing that shot based on here? What time was that? Oh, there it is. Right, I've only gone by it 5 times. All right, please raise your right hand. Do you solemnly swear or affirm testimony about to give in this matter be the truth, the whole truth, and nothing but the truth? I do. Okay, and you heard the plea that was placed on the record, correct?
Yes, ma'am.
As to the amended charge of operating while visibly impaired, how do you plead? I'm sorry? You've gone over your advice of rights with your attorney, correct?
Yes.
And you understand all of those rights?
Yes, ma'am.
You also understand by entering into a plea that you'll be waiving some of those rights. And you understand as well the possible penalty as a result of your plea, whether in this court, any other court, or administrative agency.
Yes, I do.
Knowing all of that, do you want to continue with your plea?
Yes, Your Honor.
Has anybody promised you anything, threatened you, or coerced you in any way for you to enter into a plea? All right, any immigration issues?
No.
All right, counsel, if you can please hear your client.
Ms. McFall, were you operating a motor vehicle in the city of Wyandotte on June 3rd of this year?
Yes.
On that date and time, were you pulled over by a Wyandotte police officer?
Yes.
Prior to driving, did you consume any alcohol?
Yes.
What did you consume and approximately how much?
I consumed some tequila. It was 2 cups, but I can't say approximately how much was in the cups.
Did that tequila impair your ability to operate that motor vehicle?
Yes, it did.
Satisfied, Your Honor, most stipulations with 1.17.
Okay. So the court will accept your plea as knowing, voluntary, and factually accurate. The court will dismiss the original charge per the plea And then the court's going to order bond and conditions are continued. Ma'am, if you test right now, what is in your system?
Nothing. I've been sober since that day.
All right, how do you feel?
I'm good.
Okay. All right, I'm gonna have you go over to probation and somebody will be with you shortly, okay, for all of your next steps.
Thank you.
All right, thank you. Have a good day.
You as well.
Alrighty, friends, let's change it up. Go to Lake County, new contestant in front of Judge O'Donnell.
Your Honor, we're here in case 26 CR 560, State of Ohio versus Seth S. Merrill. Present in court is a defendant who's accompanied by his attorney, Mr. James Matthews. We were previously here on June 17th, 2026. At that time, the defendant withdrew his previously entered plea of not guilty and entered a plea of guilty to count 1, domestic violence, a felony of the 3rd degree. This matter was referred to the Lake County Adult Probation Department for a pre-sentence investigation report, as well as for a victim impact statement and a drug and alcohol evaluation. Those reports have been completed, and the state has had an opportunity to review those reports. The state is ready to proceed with sentencing. The state would move to dismiss the remaining counts of the indictment, and there are 106 days of jail time credit. Thank you.
Mr. Matthews. Thank you, Your Honor. We are asking for community control, excuse me, for Mr. Merrill in this case. We do understand this is a felony of the 3rd degree domestic violence, and that does carry a presumption in favor of prison. However, we do believe that that presumption can be overcome in this case. I do not believe there's anything about the facts of this case that would mean placing him on community control sanctions would demean the seriousness of the offense. Mr. Merrill had a very chaotic and unsupervised upbringing. He left school in the 7th grade, has a history of drug and alcohol abuse throughout not only his childhood, but his adult life as well. He is definitely in need of help and guidance, and he has been interviewed and accepted at the program in NeoCap. He should very likely, according to the recommendation in the drug and alcohol evaluation, follow that up with a minimum of 6 months in sober living. But most importantly, throughout the evaluations, he indicated a strong desire to get help and to try to change the path that he's been on for really pretty much his entire life. And he is hoping that despite his record, which we obviously acknowledge does have an impact on things. It's, he has multiple probation violations, he has prior prison, but he's never had the opportunity to get the kind of help that can be given to him through the programs I outlined earlier and that were recommended in the drug and alcohol evaluation. So he is hoping the court will give him that opportunity, Your Honor. Thank you. Mr. Merrill, what do you want to tell me?
Sir, if I may stand. I just want to say that I messed up when I should have had a little more control of myself. I deeply apologize.
Isn't this kind of a pattern for you?
It may look that way, sir, but I haven't been in trouble in 5 years. I've been doing good.
Wait a minute. Wait.
Yes, sir.
You went to prison August of 22, were released in March of 24 on a felony battery, felony 3, placed on parole, and disappeared August 2nd of 24. What do you mean you haven't been in trouble in 5 years?
When I read the paperwork, whenever I got my indictment, it said it brought up that in my paperwork it said I got released in 22 and 23. It didn't say anything about 24, sir, so I apologize.
All right. So, well, tell me what happened with this offense.
It was a normal day. It started off well. We were getting along. I cooked. Long story short, I cooked dinner. Everything was fine. She started arguing with me. I didn't understand why. And then I asked her to use her phone so I can. I use marijuana to go to sleep. I have insomnia and night terrors. I use marijuana to go to sleep. I asked if I can call my friend to get some marijuana, and she said yes. I used her phone. I found messages where she was cheating on me. When I told her so, after I packed her things and gave her the bag, she became belligerent and angry. And I wasn't trying to listen to anything she had to say, so I walked to the couch. I sat down. She said, "Why don't you want to hear anything I have to say?" I said, "Because I don't want to use that language in the courtroom." But I said,
Well, tell me what happened. I don't.
She struck me with her phone, and she was on top of me, and I pushed her off of me. And when I pushed her, my hand hit her lip, and
So that's the domestic violence?
I don't know, sir.
Well, you pled guilty, right?
Yes, sir.
Who was she to you?
She was my fiance at the time.
How long have you known her?
About a year and a half.
Why did you leave Florida?
I left Florida because I wanted a new start.
Okay, you were on parole, though.
I had already violated. They told me they wanted me to come in, and it was just all I have to do is 60 days in Florida. She said, it's up to you if you want to come in. I'm not worried about it, is what my parole officer told me, and that's the truth. And I said, well, I got things I got to take care of. And she said, that's your choice, that's your decision. You're a grown man. I said, yes, ma'am. And then after that phone call hung up, I got a Greyhound ticket up to Elyria from Cleveland. I got dropped off at the Cleveland station and got picked up in Elyria.
Why'd you come here?
I wanted to get away from Elyria because I was.
No, I mean, why'd you come to Ohio?
I just wanted to get away from Florida, old habits and old friends. I just wanted a fresh start, sir.
Okay. Well, the habits haven't changed, have they? What kind of drugs are you using?
Methamphetamines.
You were doing the same thing in Florida, right?
I don't understand, sir.
Well, you said you wanted to get away from things, to change things, but you're doing the same thing here you did in Florida, right?
I fell back into old habits, which is why I left Elyria. I came out to Madison.
Who lives on Clyde Road in Madison?
That was the house I was renting.
Renting it from who?
Alex Carsell.
Where were you working?
I was doing self-work. I do painting and maintenance.
So you rented this house from who?
Alex Carsell.
And how much were you paying a month?
I was paying $250 a month, and I was putting food in the house.
Who else lived there?
His girlfriend and her young son. I think he's about 3 years old.
Was everybody at that place using drugs?
Not that I know of.
Okay. Was everybody at that place using drugs? I mean, we know it's a drug house. Okay?
I guess so, yes,
so
sir.
don't.
Yes, sir.
Okay. When I ask you a question, I'm asking for a reason.
Yes, sir.
It's because I want an honest answer. Okay.
Yes, sir. I apologize.
All right. So, and your intention is to go back to live at that place, right?
They asked for an address. It's the only one I have. But if that was failed to succeed, I was going to go to Project Hope, which I prefer.
Who lives on Willow Drive in Painesville?
That was a female I was talking to since I've been incarcerated. And
who?
Cheyenne Goochner.
How do you know her?
I met her through one of my friends.
Which friend?
Mariah Mayo.
So you've never met this person before?
In person?
Right.
No, but she's came to visit me. We've been talking for the last 3 months. But we stopped talking because I think her uncle works at the jail and he didn't approve of it. So she chose to respect his wishes, which I respect as well.
So what am I supposed to do with you? You've been committing violent crimes in Florida, and you come here and here you go again. What am I supposed to do with you?
Sir, I just want an opportunity to prove myself that I'm actually willing to make that change, and I have a change of mind and heart as well. I just asking for an opportunity, sir. I understand I did something
You,
wrong.
you had a lot of opportunities in Florida, right? You were on
Not really.
probation in Florida.
Not really. Florida's
No?
judicial system is very messed up.
I guess it depends on your perspective, right?
Yes, sir. From my end of it, it didn't seem like I had very many opportunities.
In Duval County,
Yes, sir.
in 18 for a battery, you were put on probation for 6 months. It was October 20th of 18.
Yes, sir. I was very
And
young.
November 19th, there's a probation violation.
Yes, sir. I was very young.
Okay, well. You managed to elude them until June of 19. You were on probation in 21 in Duval County, and you violated. And they sent you to prison. So why is probation suddenly going to work now?
Because I feel what I've seen and heard from my lawyer and from what I did a little research myself with the Lifeline program and everything I found about NeoCap, that there's a lot of more opportunities for me to be successful due to the programs that they offer with probation and also rehabilitation on the mind as well as physical. And I just want an opportunity to prove myself and take advantage of this situation so I can get my life together because I'm still young. I still have
What is getting your life together look like?
I've never had my life together to begin with, so getting my life together would be a job, a car, a house that's mine. You know, doing things that are. I don't want to use the wrong words. So I'm not very literate. Doing things that are good.
Productive?
Productive, yes, sir.
Okay.
I just want an opportunity to prove myself. That's all I'm asking for, sir. I feel like if you gave me an opportunity, you wouldn't be let down. I really want to do this. I really want to prove not only to you, but to myself as well.
Now, how do I reconcile the fact that you tell me this and that you just disappeared from Florida because you didn't want to show up?
It wasn't because I didn't want to show up. They violated me because I wasn't on time. I was 5 minutes late, and then she called me after I left the visitation, not the check-in, and she was like, "Oh, I'm gonna have to violate you because you were 5 minutes late." I was like,
I don't think I believe that.
Sir, I'm being honest. She said, I've never had a dirty urine. I was never late before, and she violated me because I was 5 minutes late because I just got off of work. And I was working for a lawn care service when I was in Florida. And because of that, I was angry, and I made a dumb decision by not going back in. And I came out. I mean, coming out here wasn't a dumb decision to me because I got away from certain extremities in Florida.
Got away from what?
Certain extremities. Like people that I don't care to associate with anymore.
But you're associating now with the same crowd.
I fell victim to it for a short period, yes, sir. And me being incarcerated and getting away from it has opened my eyes to me getting back on track.
You've had some problems over here in the jail. What's that all about?
Somebody was disrespectful to me, and I told them about themselves. And after I walked away, he tried to run up behind me, and I turned around and I kicked him in the face because I felt threatened, and I felt like I had to defend myself. Because he was running up behind me as I was going up the stairs.
Who was that?
Somebody that went home. I forget his name. He already went home months ago, or a month ago, something like that. I just felt like I had to defend myself. He ran up behind me in an aggressive manner. And me being incarcerated in Florida, there's a lot of violence in Florida in the prison systems.
There's a lot of violations over here in the jail. There's a line on the floor that you're not supposed to cross to go observe whatever is going on somewhere else, and you did it anyway. Why did you do that?
Sir, I've never got informed about that.
Okay. Okay.
Only thing I was in violation of that I know of personally was a ripped T-shirt and the incident I just brought up with me kicking the person in the face. Sir, I don't know.
What's with the ripped T-shirt?
The ripped T-shirt, it was a mistake.
What do you mean it was a mistake? Did you rip the T-shirt?
Yes, sir. I ripped.
So it wasn't a mistake. You ripped it.
It was.
It seems like a silly thing, right? Okay, but you do stupid shit when you know you're not supposed to do it, but you do it anyway. You used your teeth to rip the sleeve off a thermal and then threw the thermal off the mezzanine toward the trash can. I mean,
I was making a rag to clean my room.
Okay.
So, because they put me in a dirty room.
You don't like to, if you don't like to do what you consider silly stuff that should be nothing, then why don't you keep yourself out of position for people to tell you to do silly stuff you don't think you should do. You're the one that put yourself here.
Yes, sir, I agree.
Okay, you've been putting yourself in places like this for 15 years, right?
Yes, sir.
Okay. And you don't seem to think it's a big deal because it was a dirty room and you wanted to clean it, right?
I understand.
It's a jail.
I
It's a jail.
Yes, sir, I understand.
It's not a hotel.
Yes, sir.
Okay. So what is it exactly, regardless of what I sentence you to, what is it exactly that you're going to do with your life when your penalty for this incident is over?
Well, I actually planned on getting my GED in the process because they helped me with that as well. I heard at NeoCap if I was to get that. I would like to take college courses and get, because I was actually very smart in grade school and middle school. I would like to get back on track with my education and actually make something of myself and pursue either business or financial. I wanted to start my own business.
Okay. What's the tattoos on your face?
Actually, the one that looks like teardrops is actually a semicolon for suicide awareness for my friend that killed himself. The 6s on my face is for me, my sister, and my brother. I used to practice a dumb religion that I don't practice anymore.
666?
Yes, sir. I'm not a part of that anymore. I'm actually Christian. I read the Bible every night. I got a Bible open in my room right now. I got 2 of them in my room. I read it every night. I've changed my outlook on my religion. But it has a double meaning. It was for that and also for me and my siblings. And then I have a cross on my forehead, and then everybody's a sinner. And then I have a broken heart because I've been heartbroken before by a female.
Okay.
I got most of these when I was young.
All right, you going to get that stuff off your face? You talk about you want to get your education, you want to you start your own business, be involved in finance, and somebody comes to see you.
I understand where you're coming from. If that's what it takes for me to be productive, then yes, I will.
Well, you decide. I don't care if you do it or not.
I've been thinking about it. Yes, I will get it off my face. I will. Actually, I've been already thinking about that.
Who is the girl that's the subject of this domestic violence? What's her name?
Angela Spagon.
And you said you knew her for a year and a half?
Yes, sir.
When's the last time you had any contact with her?
The day I got arrested, sir. I haven't talked to her not one time.
All right, anything else you want to tell me?
I deeply apologize for putting myself in this situation in front of you, and I'm just asking for an opportunity, sir, that's all.
Okay, Ms. Himmeline, have a seat.
Thank you, Your Honor. The state would note that it appears the defendant has told the court a lot of things that he thinks this court wants to hear, but he's really full of excuses. He is blaming the victim for what happened and has shown no genuine remorse. while the injuries from this particular offense are not the most severe, there was a history of domestic violence in this relationship. The defendant does have a lengthy criminal history, which includes multiple offenses of violence, a significant number of probation violations, and as the court noted, he was on parole at the time of this offense. The defendant said he hasn't been in trouble in 5 years, but the parole violation was issued in Florida in August of 24. By January of 25, he was already committing crimes in Elyria. And then throughout August, November, December of 25, he was committing crimes in Ashtabula. As the court is aware, he has not followed the rules in the Wake County Jail and has continued his acts of violence. Additionally, the state would note that the defendant has had opportunities for treatment. Ashtabula ordered him to attend intensive outpatient treatment through Turning Point, and he left because, quote, the staff was disrespectful. So he left that program early, went to Impact Therapeutics, and then left that program.
How was the staff disrespectful?
They were inconsiderate of my psychological affairs. Whenever I was coming off of drugs, my mental state wasn't in the best of I don't know how to put it. My mental state wasn't all right, and when I asked for a little bit of space to let me, they were driving too hard, and I left Turning Point for a matter of 5 minutes and called my sponsor and was immediately inducted into Impact Therapeutics in Andover, Ohio. I made the right decision by calling my sponsor. Mind you, sir.
You keep placing yourself in a position where you want to dictate what the terms are, and you don't have the luxury of that because you keep putting yourself in these positions.
I understand, sir.
Go ahead, Ms. Himalayan.
Thank you, Your Honor. After leaving Turning Points, he went to Impact Therapeutics in Andover and also left that program early. So for all of those reasons, the state is requesting that the court impose a sentence of prison in this case. Thank you.
What mental health diagnoses do you have?
ADHD, OCD, chronic manic depressive, night terrors, insomnia. It's very extensive, sir.
Who diagnosed you with those?
Dr. Black at Impact Therapeutics, and also ADHD was through a...
Why did you leave Impact then?
Sir?
Why did you leave Impact?
The female that I am in jail for currently, because she told me that if I didn't come get her, she was going to go back to the streets, and I deeply loved her at that point in time. I threw away my rehabilitation for her.
Does it say why he left Impact?
It just says that he left early for his girlfriend.
Okay. So you were left to take care of her.
She was at New Beginnings, sir, and she called me, said, I'm going to leave, I can't take you here no more, either you come get me or I'm going to go back to the streets and do whatever I was doing. And I didn't want that for her nor myself, so I went, got a ride to Ashtabula, got her from New Beginnings, and I found a room for rent online, the Alex Carsell in Madison, and I paid him. I started working, I paid him rent, and we moved in over there in Madison, and that's where this starts.
So you didn't address your problems, right?
Yes,
you
sir.
didn't address your mental health diagnoses that were just made, right? You didn't address your drug addiction. You decided to save a girl, and you can't even save yourself. So how's that work?
I was in love, sir. I was blinded by things that I don't have that are a part of me anymore. I'm fully focused on myself, and there's nothing stopping me. I have no female in my life. I have nothing to stop me from what I want to actually accomplish.
Is there a warrant out of Elyria, Dave?
There is. Yeah, for it was a possession of drug abuse instruments. It occurred in 2025.
Why didn't you show up in Elyria?
Because I was currently out of town in Brunswick and got stuck out there.
Elyria, how far is Elyria from Brunswick?
I believe like 45 minutes, sir, or an hour.
Yeah.
I don't know, I'm not from here.
Why didn't, when you went back in town, why didn't you go back and clear that up? Because you didn't want to, right? You didn't want to go.
That's not true.
You didn't want to go to jail.
Yes, sir.
All right, I've reviewed the pre-sentence report and the drug and alcohol evaluation. Listen to what you have said, what Mr. Matthews, Ms. Himmeline have said, considered all the provisions in 29, 29, 11, 12, and 13. You know, and I'm going to find you've overcome the presumption of prison. I'm going to place you on community control for 5 years. And I'm doing that not because I believe anything you tell me.
Yes, sir.
Okay? But this is what I think is appropriate at this time.
Yes, sir.
Okay? But don't misunderstand that I necessarily believe that you want to do anything different, because you haven't demonstrated that yet, even while you're over here. You're going to serve 180 days in jail with credit for 106. The last 30 you'll be in the jail treatment program. You're going to complete that and follow all recommendations. And you're going to go directly to the NeoCap program. You're going to complete that program. You're going to follow all those recommendations. Then you're going to do a minimum of 6-month period in a sober living facility. Complete it and follow recommendations. You're going to get a mental health evaluation. And you're going to follow those recommendations. You're going to attend at least 4 AA or NA meetings a week. And get a sponsor. You're to have no illicit drugs or alcohol, and you'll be screened. You're to go to only one doctor and one dentist and one pharmacy for prescription medication. You're to take your medication only as it's prescribed. You're going to sign releases for probation. You're going to get your GED. You're going to get a valid driver's license. Have you ever had a driver's license?
No, sir.
You're going to obtain and maintain full employment. You're to have no contact with Pagan. You're going to clear all your outstanding warrants.
Yes, sir. I have a question, sir.
Yep.
With me being released from NeoCap and everything, how would I clear my warrants without being in violation of my probation?
I would figure out a way to do that with your probation officer. Okay? Because what, you don't want to clear your warrants?
I do want to clear my warrants, sir, but I feel like if I was to go try to clear my warrants, they would incarcerate me, and that's in terms of a violation of my probation.
Well, why don't you let me figure out what a violation of your probation is? Okay?
Yes, sir, I apologize.
Okay, because I'm telling you, you got to clear the warrants. And if in the process of clearing the warrants you show up at Elyria and they put you in jail, I'm not going to violate you for doing what I told you to do. Okay,
Yes,
so you let me figure out what is or isn't. You follow the rules.
Yes, sir. It's just different in Florida. They would have.
We ain't in Florida, okay? You ain't in
That's what I'm
Florida.
used to. Yes, sir.
Okay.
Thank you.
And you're going to pay the costs and supervision fees. Mr. Tompkins, any other terms?
Judge, may I make a suggestion? Instead of 6 months sober living after NeoCap, would Lake House or Concord Pines be appropriate? Considering if he goes to sober living, he might actually have to pay rents. I'm assuming he won't have any money coming out of NeoCap.
Okay. So we'll do that. You're going to go, after you finish NeoCap, instead of sober living, you're gonna enter into and complete the program at Lake House or Concord Pines and follow those recommendations.
Yes, sir, thank you.
You understand all the terms?
Yes, sir, I do.
Any question about the terms?
No, sir.
If you violate the terms, the state will file a motion to terminate your community control. If I find you violated, then you'll go to prison for 36 months. You understand that?
Yes, sir, I do.
And then you'll be on post-release control for up to 2 years after your release with conditions. If you violate, then you can go back to prison for various lengths of time, okay? And so I guess you could skip town and go somewhere else if you want, but now you have no excuses. You come here saying you never got the opportunity for treatment when you did, okay? But you've got the opportunity for all the treatment that you need to be productive, which is what you say you want.
Yes, sir.
Okay. So wherever you go next, whatever court you go to next, if you commit another crime, they're going to see what you had the opportunity to do, and they're not going to believe you either. So you figure out what you want to do. Remaining counts are dismissed. Anything else, Ms. Himalaya?
Just to clarify for the record, Your Honor, a violation would lead to prison of up to 60 months. This was a high-tier DWI.
Oh, 60, okay,
yes.
yeah.
Thank you, Your Honor.
Not 36, 60. You understand?
Yes, sir.
Mr. Matthews, anything else?
No, Your Honor, thank you.
All right.
Alrighty, friends. A few more minutes left for TCF Live for today. Let's go back up to Judge DeSanto, see if we can get one or two more hearings in with her.
Today's date scheduled for the arraignment and pretrial in this matter. Counsel as to the arraignment.
Mayor, prepared to waive the formal reading. My client stands mute.
The court will waive the formal reading, enter a plea of not guilty for purposes of the arraignment, and then ask the pretrial counsel.
Yes, Your Honor, at this time, the city attorney has offered to amend the original operating while intoxicated to one count of operating while visibly impaired. Mr. Turner would like to avail himself of that offer and enter a guilty plea.
Please raise your right hand, sir. You solemnly swear or affirm the testimony you're about to give in this matter be the truth, the whole truth, and nothing but the truth.
I do.
Okay, and you heard the plea that was placed on the record, correct, sir?
Yes.
As to the amended charge of operating while visibly impaired, how do you plead?
Guilty?
You've gone over your advice of rights with your attorney, correct?
Yes.
Then you understand all of those rights.
Yes.
You also understand by entering into a plea that you'll be waiving some of those rights.
Yes.
You also understand, sir, the possible penalty as a result of your plea, whether in this court, any other court, or administrative agency.
Yes.
Knowing all of that, do you want to continue with your plea?
Yes.
Has anybody promised you anything, threatened you, or coerced you in any way for you to enter into a plea?
No.
Any immigration issues?
No.
Counsel, if you can please forward to your client.
Mr. Turner, were you operating a motor vehicle in the city of Wyandotte on June 25th of this year?
Yes.
Were you pulled over by a Wyandotte police officer?
Yes.
Prior to driving that evening, did you consume alcohol?
Yes.
What did you consume approximately how much?
She's right.
Like 4 beers. Satisfied, Your Honor, it'll stipulate to a point from 0.
All right, the court is satisfied that she is knowing, volunteering, factually accurate. The court will accept your plea to the amended charge, dismiss the original charge per the plea agreement. And counsel as to bond.
Yes, Your Honor, I would like to know, Mr. Turner, there's a retired military police officer. He has no prior criminal history. He's not on probation or parole, no pending matters that did appear here today. And thirdly, he would be, if tested today, he likely would test positive from there. He does use gummies for sleep purposes only. I would just ask for consideration for a personal bond.
All right. Sir, do you have any medical recommendation for you to use gummies from a treating physician?
I did explain that to Mr. Turner. He was going to talk with his doctor regarding that.
Okay, let me just give you this information, sir. If you, so when you go to probation to get all of your next steps, you can ask for we have a checklist. I think there's about 5 things that need to be included in the letter from your doctor.
Okay.
Okay?
Yes, ma'am.
Just be aware. If your doctor says, puts all that in writing, that's not your permission to use it. That has to get submitted to the court. The court will review, and then you will receive something back in writing. And then, depending on if that's favorable for you in that regard, then you can start using again. Okay?
Sure. Yes.
All right. And would there be anything else detected in your system? There's no talking in court. No? All right. Have you ever failed to appear in court for any reason?
No.
All right. On bond in any other jurisdiction?
No.
All right. The court's going to continue your cash bond. You're not to possess or consume any alcohol or drugs unless prescribed. They're going to copy your bond conditions and all of your next steps when you go back over to probation. Okay, sir?
Thank you, Judge.
Thank you. Have a good day.
Alrighty, friends, that will do it for today. Thank you for spending some time with me this morning. Very much appreciate it. We'll be back tomorrow morning, 9 a.m. Eastern, 6 a.m. Pacific. So I do hope to see you then. The wisdom I leave you with today from Bob Dylan: a hero is someone who understands the responsibility that comes with his freedom. So chew on that as you go throughout your day, and look forward to seeing you all tomorrow. Take care. God bless.